Yes. Okay. Yes, year. No, 21. The next SAMUA. And 20. Yeah. So you want dependent one. Well, all of the things they get, but that's the 3. Okay, guys, thank you.
Mr. Evelyn, good morning.
Good morning. Good morning, Ron. How are you doing?
Good, how are you?
We're doing fine.
What can I do for you today?
We have a probable cause conference. We've got discovery. We have a June 1st exam date. We just want to confirm that date, Your Honor. That's all.
Defendant.
And we've been provided all discovery, so we're ready to proceed.
Who is the defendant?
That would be a good thing to tell you, the defendant. Lakira Anderson, Your Honor. Lakira Anderson. I apologize.
No problem.
And she's on now.
Ms. Pilkowitz, who are you here for?
I'm here on Justice Biffle, Judge. I'll be waiving her presence.
Biffle, okay. All right. Hang on, guys, waiting on the prosecutor.
Okay.
Mr. Anderson, Mr. Higby.
Good morning, Your Honor. I'm here with Mr. Evelyn on behalf of Lakira Anderson.
Okay. We're just waiting on the APA to sign in.
Thank you, Your Honor.
Jones. Can we be sure that the jail is gonna be? Cause that's. I said, no, it's supposed to be in person.
There's two Joneses on here. You're talking about Sierra original.
Not Jones, but this. It's a bond.
Just name.
I can look at her. The one that said bond.
Good morning, Ms. Dren.
Good morning, Judge.
Section District Court.
Okay. First up is Mr. Pilkowitz with Biffle.
Calling case number 2305-689901. People understand Michigan versus Justice Biffle. Defendant charged in count 1, assault with intent to do great bodily harm, death, murder, or by strangulation. Count 2, domestic violence.
Appearances for the record, please.
Morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz, PA1653 on behalf of Justice Biffle. I just spoke with her yesterday. I'd ask that the court waive her presence for purposes of this proceeding.
For the waive the defendant's presence, what's your pleasure?
Your Honor, I am in receipt of discovery, both paper and digital. We're just asking for an exam date at this time.
All right, the court will continue to plea of not guilty and set this matter for preliminary examination. How is, let's see. May 31st at 11:45.
Judge, I have a matter in circuit at noon. I have two other matters before the court at 10:30 and 10:45 that day. I am wondering, I do anticipate this being a dismissal. It's my understanding the complaining witness does not wish to proceed. So perhaps we could set it for 10:45 or 11.
Okay, don't cause me any problems then. 10:45 on May 31st.
I won't, Judge. And if I may address, bond.
Go ahead. I'm listening.
I'm sorry, Your Honor.
I said I'm listening.
Oh, yes. Your Honor, there's currently a no contact order in place with the listed address where the incident is alleged to have occurred. I believe that address is on Dexter Street. That is Miss Biffle's, she's the owner of the residence at that location. I believe the complaining witness was staying there at the time. It's my understanding that he is no longer there. I would ask that the court consider lifting the no contact provision so that she can return home.
That's going to have to be verified through the prosecutor.
I understand, Judge.
And I will certainly call the,
Put your heads together on that and you can send over a stipulated order.
Thank you, Judge.
Okay, thank you. Mr. Evelyn, you're here on Anderson.
That is correct, Your Honor. Good morning.
Good morning.
Calling case number 2305-614701. People of the state of Michigan versus LaKira Anderson. Defendant is charged in count 1, assault with a dangerous weapon, count 2, malicious destruction of personal property, 200 or more but less than 1,000. Defendant has a felony commission with the motor vehicle advisory.
Appearances for the record, please.
good morning, Your Honor, Shelley Drain for the people, P number 60249.
May it please the court, Gerald Evelyn, P 29182 on behalf of defendant LaKira Anderson, Your Honor.
And good morning, Your Honor. May it please the court, Robert Higbee, P 82739, appearing as co-counsel on behalf of Miss Anderson.
Tell us your name for the record, Ms. Anderson. Tell us your name.
LaKira Anderson.
What's your pleasure, counsel?
Your Honor, we've received all discovery in this matter. We currently have an exam date of June the 1st. We'd ask the court to confirm that date for exam. Thank you.
Actually, Tuesdays and Thursdays are my homicide days. So
Okay,
it won't
well,
be first, we can do June 2nd.
June 2nd is not a good day for me. The 31st of May is fine, Judge, if that's okay. Or June, I guess June 6th.
We can do May 31st at 12:30.
That works fine, Judge. May 31st at 12:30.
All right, May 31st at 12:30, bond will be continued.
Thank you, Judge.
Thank
Thank you,
you.
Your Honor.
Have a good day. See you later, Mr. Rain.
Thank you, you as well.
You as well, thank you. And those are the only two matters I had up this morning, so
Okay,
I guess I'm done.
that you are. Have a good day.
Okay, you too, thank you. Bye-bye.
Okay, close dismissals for tomorrow.
Oh, boy. We'll see.
All right.
Okay.
Mr. Montgomery. Mr. Montgomery.
Morning.
Good morning. How can I help you?
I am appearing on behalf of LaKira Anderson.
She retained you out.
Okay. I will close that file. Thank you. Have a great weekend.
Thank you, you too. Good morning, Ms. Michon.
Good morning, Your Honor. How are you on this fine Thursday?
I'm well. How are you?
Thank you so much.
You-
I know you're going to, I'm sorry, I apologize for interrupting.
No problem. You're here for Ms. Jones, right?
I would like, I assume she's going to appear on screen. I'd like the opportunity to at least advise her that I can no longer represent her.
Okay, we'll wait on it. I haven't had the Wayne County Jail chime in yet, though.
Well, given the nature of why I have to withdraw, I think it only appropriate and best practices, given her mental state, I at least have a nice conversation with the young lady.
Okay.
And have we heard from a Miss Wallace? I also represent Miss Wallace, but the appointment nor the discovery had a good phone number for the young lady.
I'm curious from Upshaw. Wow.
Okay, it looks like she may have retained you out, Mr. Upshaw.
Oh, lovely. That takes care of that one. Then I will wait ever so patiently for the Wayne County Jail.
All right, thank you so much.
Thank you, sir. Apologies, Judge.
What's up?
I'm so sorry. Do we happen to know, I know you were being very forthcoming and making sure we had somebody here to take over dear Miss Jones's matter. Do we know who that might be, perchance?
Attorney Bertram Johnson just called.
Bertram Johnson.
Perfect. I will reach out to him.
Okay. Wayne County Jail, are you there? Okay, good morning, Wayne County Jail. Mr. Kehoe, are you on Jones?
Good morning, Your Honor, I am.
Okay.
Good morning, Judge King.
Good morning, sir. How are you?
I am all right. I got Miss Sierra Jones for you this morning.
Okay, very well, thank you. I guess we can call it.
Calling case number CR234-2305-683101. People of the state of Michigan versus Sierra Jones. Defendant is charged in count one, homicide, murder, first degree premeditated.
Appearances for the record, please.
Good morning, Your Honor. My name is James Kehoe and my P number is 82812 on behalf of the people.
And good morning, Your Honor. May it please this most honorable court. Kim Michon, Neighborhood Defender Services, P59167. And it's my privilege to represent Ms. Jones this morning. Judge, I met Ms. Jones according to the MIDC standards within the 72-hour rule. That was prior to having the discovery in the matter. Once we had the discovery, we ran a conflict check within NDS, and unfortunately, I have no choice. I have tried every which way to see if we could shore this case off from other matters within NDS. I've spoken to Kristen Lavoie, who's our training attorney. I spoke with Mark Procida, and I even spoke with Christine Longstreet, and there is absolutely no way we can shore this matter off, and I have no choice but to regrettably move to withdraw because of that conflict. It would have been a pleasure and a privilege to help this young lady.
And you brought that to the court's attention, being the proactive attorney that you are, and I appreciate that. And that being the case, the court did call the assignment clerk to get Ms. Jones new counsel. And I'm of the understanding that was done. Who was the counsel that we're waiting on?
Bertram Johnson.
Bertram Johnson is going to be the new assigned counsel to this case. I think I might have Mr. Johnson's. And Mr. Johnson isn't answering right now. But court just signed the order for your motion to withdraw as counsel. It has been granted. Thank you, Ms. Michelle.
Of course. Judge, may I have a moment with the young lady to explain what just happened?
Sure.
Thank you so much.
Go ahead and join the breakout room.
Thank you.
Comes Mr. Upshaw. Good morning, Mr. Upshaw.
Good morning, Your Honor.
You're here on Wallace?
Yes, I am, Your Honor.
Okay, we can call Wallace. Oh, do we have an APA here for Wallace? It doesn't look like it.
Judge, what's the first name? I'll track whoever it is down.
Malika, M-A-L-I-K-A, Ashante Wallace.
Thank you, Judge. I'll check right now.
Should be child abuse. Does the name Tiffany Woods sound familiar to anyone?
That's the prosecutor on this.
Oh, is it? Oh, she's been trying to get in. I didn't know that. Thank you, Mr. Johnson. Good morning, Mr. Johnson.
Good morning, Your Honor. I had the wrong Zoom ID. I had to get the right one. I had your old one.
No problem. So you're here for Ms. Jones, right?
Yes, Your Honor.
I'm gonna put you in the breakout room with Ms. Jones.
Okay,
She's
thank you.
Ms. LaShawn, who was the counsel that had to withdraw. Go ahead and join. Ms. Woods,
Yes, Your Honor.
I apologize for leaving you in the waiting room so long. I had no idea you were the APA.
Sorry, Your Honor. I wasn't sure if I was having technical problems or what was going on, so.
You have to put APA before your name so I know who you are. Otherwise, I'll leave you there because we have a lot of weird people trying to do weird things in front of us, and I don't like it.
Oh, okay, Judge. Sorry, I didn't know that. I'll make a note of that and do that next time.
Okay. So we are ready on Wallace.
Calling case number 2305-691601, people of the state of Michigan versus Malika Wallace. Defendant is charged in count 1, weapons, firearm, discharge in or at a building. Count 2, weapons, felony firearm. Count 3, malicious destruction of personal property, 1,000 or more, but less than 20,000. Count 4, child abuse, 4 to 3. Count 5, malicious destruction of building, less than $200. Count 6, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. APA Tiffany Woods, P86189 for the people.
And good morning, Your Honor. Randall Upshaw on behalf of Ms. Malik Wallace, P number 43574. I waive for appearance for this PC, Your Honor.
Court waive the defendant's presence. What's your pleasure, Ms. Upshaw?
Your Honor, we need an exam date.
All right, court will continue the plea of not guilty and set this matter for preliminary examination. How is June 2nd at 10:30?
Your Honor, I can't do June 2nd. I'm actually going to be with Judge Hathaway that morning.
You don't want to make it later on in the day when you get through? Because
I can do later in the day, just in the morning I can't.
Oh, okay.
June 2nd at 12 o'clock.
That works for the people.
That's fine, Your Honor.
All right, June 2nd at 12 o'clock. The bond will be continued.
Have a good day, Your Honor.
Thank you,
Thank
Your
you.
Honor.
Then this person saying he knew something about, yes, they would have sent a tender and said that, put on tender, like confirmation statement, so he can turn it into his job. When I left the probation, they told me I had to come down here and have a court order and give it to them. It hasn't been. Yeah, this is, we haven't had.
Are you,
So the Judge McConnell put him on the top, is that right?
He said he was in your courtroom.
can I have a little bit more time with Miss Jones in the breakout room?
Okay. Go ahead and join.
Thank you.
It was a rain yesterday,
That's why I didn't.
so he hasn't been before me, unless it was before me at some other time. And the case got dismissed and they reissued.
So that's what I was trying to understand. I just know he said he was in King courtroom, so I came here, I went to probation first and see if they had it.
I doubt if he's confusing me with Don White. We don't look anything alike.
No, y'all don't. What's his name?
Wayne Thomas.
Wayne Thomas. See anything for June 2nd? Yeah, I don't have. So in other words, he just don't have to wait, or I need to find out the judge he really in front of. In order to get the court order. So it's downstairs.
How was he even released if he didn't get a tele?
I don't know. That's why I don't be understanding a lot of stuff that comes across. Work.
And he needs to do what?
Talking about them, on tether for his job, he needed confirmation because it was going on wrong, he needed confirmation for his job. That's what he said, he had to turn it into. It was just a, yes. I would think it would. Okay. Yes. Okay.
It says obtain a GPS tether by 12 p.m. on May 26.
Morning. Morning.
Hey, good morning. How are you?
Good. You looking like you don't even know who I am.
Good, guys.
Uh-huh. I was. Good morning. Getting ready. Good. How are you? Good. You too. Mhm. My God. So, yeah. Never in the fourth grade. Yeah, fourth grade. What did you
I'm ready on Sierra Jones, Your Honor.
Okay, here I come. One second. Right. Okay, we are back on the record on People versus Sierra Jones, case number 23056833101. Appearances for the record, please.
Morning, Your Honor. My name is James Kehoe and my P number is 82812 on behalf of the people.
Good morning, Your Honor. May it please the court, Bertram Johnson appearing on behalf of Sierra Jones, P46646.
Ms. Jones, unmute yourself and tell us your name.
My name is Sierra Jones.
Okay, so before we begin, I have some disclosures to make. First and foremost, I was pretty good friends with Ms. Jones' father, who was a well-known attorney that practiced in this building as well as in all throughout the Third Circuit Court as well as the state of Michigan. In fact, I knew her father so well that I actually spoke at his funeral. And I met Miss Jones when she was about 3 or 4 years old. I've not seen her since. Last time I saw her, I think she was about 4 years old. So I don't have any relationship with Miss Jones or her brother or her mother. But I am familiar with Miss Jones as well as her brother, her dad, and I don't think I've ever met the mother. But I wanted to make that disclosure just in case anyone has any objection to me staying on this case. Let me say for the record that I think it would not be a problem for me going forward presiding over this case. I think that I can be impartial. In fact, I know I can. Does anyone have any objection to me staying on this case?
Judge, at this time as counsel, I have no objection. As far as a conflict, there's we first start whether there's a potential for conflict. And I don't see any potential for conflict at this time. And I clearly do not see a conflict of nothing's been brought to my attention that would indicate that there is an actual conflict at this time. So therefore, I have no issue with this court remaining on this case.
All right, Mr. Kehoe.
I have no objection, Judge.
Okay, very well. Okay, what's your pleasure, Mr. Johnson?
Your Honor, obviously I've just spoken for the first time with Ms. Jones. I also spoke with prior counsel. There were some discussions about referring her for competency prior to the exam. I've spoken with her at length. After speaking with her based on her disclosures, I thought it would be effective and competent on my part to refer her. As I indicated to her, I do believe she will come back competent, but to be effective and to be competent, I thought that as counsel, as new counsel, based on what she told me, that I should refer her. However, she appears to have some misconceptions about how this case will proceed. Hold on, ma'am. With respect to a bond hearing or something of that sort, I indicated to her there is no bond at this point on a first-degree murder. I indicated that she was not going to have a pretrial. I indicated her next hearing is a preliminary exam, and I indicated to her that forensic examination would take about 60 days, but it would also shine some light on other issues that may be helpful to her case, and that I did believe she would come back competent. At this time, she indicates she does not want to be referred. She feels it's her right to object to that, and I told her that I would let the court make that known to the court, and judge let you proceed as you see fit.
Ms. Jones, I want you to understand what the role of Mr. Johnson is, and that's to look out for your best interests. And we want to make sure that we proceed cautiously in this matter, make sure that every T is crossed and every I is dotted. So we have to start from square one. And if the attorneys are concerned that there may be some mental health issues here, we want to make sure that you understand this process. We know that you've been around the criminal courts for as long as you can talk. But we want to make sure, we want to make sure that everything is done appropriately. And in so doing, I am going to refer you for a competency evaluation. It's not only in your best interest, there may also be some strategic reasons that Mr. Johnson may be pursuing and going forth in that fashion, okay?
So would that mean my preliminary exam is gonna be pushed back, or it's gonna be not on June 1st?
No, it's not going to be on June 1st. It will be pushed back.
So if I don't have a, because with all due respect, I don't have a mental illness. My mom petitioned me into the hospital because me and her had conflict towards each other since I was a little kid. And she never called me like mental. This has just happened within this year. So I never really got put in a mental hospital before until like
Well, you're
now.
not being put in the mental health hospital now. You're going to be evaluated to make sure that you appreciate and understand the charges that are brought against you, and that you're able to assist Mr. Johnson in his defense of you. We want to make sure that that's done before we go forward. So can I get your cooperation in that?
I mean, you can, but it's like that kind of like traumatizes me when people call me mental ill because I'm not mental ill. I don't even feel like people have to go through this and they have a right to say they don't have to go through this.
Now, Miss, I've never called you that, and I'm not going to refer to you that. And I also indicated to you that I believe you will come back competent. I told you that 9 times out of 10, that I'm quite sure, but I said to be effective and to be competent, I think that we should refer you in.
Right, but
I will never refer to you as mentally ill.
Do that if I had a different lawyer, like I didn't feel like I had to do that.
I don't think any counsel would disagree with Mr. Johnson at this point. In my 27 years of practicing and knowing your dad very well, your dad knowing me very well, I think even your dad, nobody's calling you mentally ill. We just want to make sure that you're able to assist Mr. Johnson in your defense. And we want to make sure that we set forth a paper trail in that regard.
I don't want Mr. Johnson as my lawyer either.
Well, you don't get to
So if I
decide
have a
who your
different lawyer, do I still have to go through the process?
Ms. Jones, listen to me. You don't get to decide who your appointed counsel is. Mr. Johnson is a very good attorney. In fact, Mr. Johnson used to be my boss back in the day. Remember that, Mr. Johnson?
Oh, yeah.
I used to work for Mr. Johnson. He's been around for a long time. I hate to say that to you, Mr. Johnson, but he's been around for a very long time. He knows what he's doing. So he's acting in your best interest. He may not seem like it, but trust me, he is.
So if I had my other lawyer, would I still have to do 60 days?
It's actually going to be,
like the competency lawyer?
yes, because Ms. Michon also indicated that she wanted you to be referred as well. Okay. All right, so the court is going to make the referral. We'll set the review date for August 25th, 2023 at 8:30 a.m.
Yes, I would just ask the prosecutor, could he give me the discovery?
We'll be in touch, Mr. Johnson. I've got you.
Okay, thank you.
All right.
Thank you, Your Honor.
Can I get my next court date?
I will see you at the jail. I'll come over and see you, ma'am. Explain everything to you.
All right. Thank you.
Mr. Judge Kenneth,
Yes, ma'am.
are you familiar with my next court date? My preliminary exam, since it's been pushed back?
First, before we get to the preliminary examination, we have to have a determination that you are competent to stand trial. And that competency hearing is going to be August 25th. That's the next date I'll see you.
Okay, and what happens if I'm not competent?
Then they will treat you until you are competent.
I'm sorry, you said they will tell me I'm competent?
They will treat you. They will give you treatment trying to get you competent. They have a little bit over a year to get you competent. If you're not. But it does sound like, and I have to agree with Mr. Johnson, you probably are going to be found competent. But we want to get that in writing from the experts, okay?
So, right, so if I am competent, I go to trial, and if I'm not competent, I go to trial?
If you are competent, then we go to the preliminary examination. If you're not competent, then you will continue to get treatment until we can get you competent.
And so until then, I would have to stay here to get competent?
You may be at the forensic center being treated, not necessarily in county jail.
And then I won't be going to trial until then?
Until you're found competent. That's right.
Okay, I'm sorry for laughing. Okay.
Okay, thank you very much. Thank you, Mr. Johnson.
Thank you, Your Honor. Thank you.
Okay. Judge, I'm sorry for being difficult. I don't know, like, I never really had a mental illness. I feel like my mom was always making fun of me for.
Okay, I don't want you to tell me anything about your relationship with your mom or the case or anything like that, especially without your attorney being present. We don't want you to say anything that's gonna hurt you, okay? So have that discussion with Mr. Johnson, okay?
Okay.
All right. Let the deputy know
Okay,
you're
do
all
I know
set.
my next court date? It's in 60 days?
August 25th,
Okay.
okay?
Hey, how are you?
Can you go back there for a second? Yeah. This is a nice and lonely place to be right here. This is our holding cell. For bad people, people just in gangs, flash gang signs. They have to wait. Nice.
It's like a C, or is it AIDS, or is it C?
About you? You flashing gang signs too? Now you show me kicked out there. So we have good twin and bad twin?
Good twin, bad twin.
Hey. Good one, you know, it's bad twin.
But you gotta tell them what else you do in school. No, no. What you do with your hand? Show him what you did with your hand. Just show him. You ain't got to talk. Just show him what you did with your hand.
What I apologize about it. What I apologize.
So what you acting like you got a gun? Is that what that was?
What was it? That's not a game song. Would you show him again? You did that to the teacher, and that's why you got suspended from school.
Serious crazy people shot up students, killed students. They may be feeling just like that girl that I was just talking to. Went to the forensic center, and see if you got to stand trial.
No.
90 days.
No.
Man, you have jails for bad kids. This is what we put the grown ones. We have bad kids. Attention. So guess who's in those places? Bad kids. A lot of those bad kids are crazy kids. I used to work with. I had a kid who used to stick a spoon up his butt, take food and smear it on the walls. Then they used to try to fight. They don't fight fair. They get a bunch of them to come and rush you and jump on you and beat you up. I'm not telling you I'm scared, I'm telling you what I know. Happens all the time, every day. And then the thing is, you still have to go to school there. If you get up and hurt real bad, they got a hospital there too. So you get treated. You know what? They tell you what you can watch on TV, you have to take a bath, and what you can keep away from the stuff like that, that's where you get it. That's why one brought you up, they were trying to get that up so that it doesn't happen. Nice and cute girl like you. Somebody's girlfriend. Somebody's girlfriend. It's not a battery type. It won't hurt. I had a 51-year-old man crying in jail yesterday.
What time they need to get out?
I said, someone trying to kill him. Thank you. I've heard good things about Jordan. You did right.
No. Got a handsome lunch here. Thank you.
Thanks. Simulating finger, gun, teacher.
Oh, we're gonna get that together, right? It's a one-time event, right?
Some about not attention to. Fight there.
No, they don't. The younger you are, the harder time you have being, attention with the older kids. They really are again. Sophia, right? Okay. Yeah, the name stands out. 3W.
So like bad.
a little misunderstood. But everything you see is not everything you see, everybody else. You know? So you have to find some good role models, like the ones in the common, one with robes and ties. We don't have. Well, so I need a man who's a good report. I know we get to help you know where from. Okay.
Out of state tuition, very expensive.
I told you like yesterday. Who we got? Okay, I'm sorry. And twin brother, you got it back. I mean, well, the thing is, names, and I know, but yeah, I'll get this right now. And you can verify this, there's one of people more. Twins. Sometimes I'm mistaken for each other. So if one is getting in trouble, you don't mistake for your brother. And you're not in trouble. And then last names. Right. So that's a good reason they, hey, brother, I don't think you want to do that, but you was like. Oh, it's a special possibility.
So I'm actually station.
Do we have, the defendant out the sign?
Yes.
Okay.
He's on his way, yes. Okay, thank you.
Any idea why the Wayne County Jail is back? That's your Wayne County Jail.
I think that's, I was just talking to the lady.
Oh.
Oh, the down.
Yes.
Hello. Hey, you all right, man? Yeah, I see. Hey, what's going on? We got another bond.
Yes, sir.
There's a few members of my client's family, are out in the hallway. Are they allowed to come to the court?
Actually, no, because we're supposed to still be closed. And it'll be a free for all if I start letting the party clean.
I have that. I thought that may be the case, so I brought my laptop. Mind if I step out there?
Sure, that's fine.
Yeah.
I know Petra Johansson is.
Excuse me, you're
Yes.
you have to tell me.
Hey, how you doing? Got everybody ready?
Yeah.
All right. Thank you.
Is there a certain area you want to see the test?
I'll leave that up to you guys.
Okay, cool.
Okay. Good afternoon, folks. Good morning, I should say. Okay, I'm going to go ahead and press. Calling case 2356948, people of the state of Michigan versus Al Hassan Wallace Ayash.
So you go for the short.
Defendant is charged in count 1 homicide, manslaughter, involuntary. Appearances for the record, please.
Good morning, Your Honor. Ryan Elsey, people. My P number is 81329.
Good morning, Your Honor. My name is Ben Gonick. I represent Mr. Ayash. My R number is P43716.
Tell me your name for the record, sir.
Al Hassan Ayash, Your Honor.
So this is the defense's emergency motion for bond. Mr. Don?
Yes, thank you, Your Honor. Thank you for hearing it this morning. As you know, my client was charged with 1 count of manslaughter. His bond was initially set by the magistrate at $200,000 cash. It was subsequently at the bail review hearing by Judge McConnell reduced to $100,000 cash. We believe that the bond is excessive for the following reasons. Mr. Ayash is 22 years old. He's a high school graduate from Hamtramck High School. Graduated number 4th in his class with a GPA of 4.0. Did attend Wayne County Community College for a year. After that year, he began a relationship with his the woman that he married through a religious ceremony named Jasmine Sandoval. She's also present outside the courtroom, actually the wait out there. And Mr. Ayash lives with his wife, his baby, and they live in the household of my client's mother-in-law in Dearborn Heights. He has 1 pending case before Judge Knapp in the Wayne County Circuit Court for felonious assault and felony firearm involved with road rage incident. No shots were fired, but a gun was located. Mr. Ayash in that case waived his preliminary examination, and the matter is currently set before Judge Knapp. There are no histories or anything indicating a failure to appear in that case. In terms of his ties to the community, he's a citizen of the United States. His parents are also present. They're outside as well. His father is a mechanic at a gas station. His mother is a stay-at-home mother with his other siblings.
Was he born in the United States?
Yes, he was. The family also has a house in Hamtramck that they are purchasing. The house that Mr. Ayash was residing in Dearborn Heights with his wife and child, and his wife is currently pregnant with her 2nd child, is also being purchased by the mother-in-law. At the time of the incident, Your Honor, just talk briefly about the facts of the case without really trying the case. At the time of the incident, this isn't a manslaughter case where someone's driving in a reckless manner or shooting a gun in a reckless manner. Mr. Ayash was at his place of employment. He worked at a mobile station in the city of Detroit. He doesn't own the station, he's simply an employee there and was given directives as part of his employment. If any patron of the store or customer of the store steals anything, they got these automatic locks, and to lock the door, we'll call the police. That's precisely what happened on the night in question. The shooter, Mr. McCray, who has a history of, unbeknownst to my client, has a prior criminal history of armed robbery. After he served, I believe, 4 or 5 years, he was paroled. And within a year of committing parole, or being discharged from parole, he picked up a felony firearm, CCW felony possession case in Wayne County. Prosecutor's office ultimately offered probation in that case. And he was and his probation status at the time of the homicide was there was a warrant issued for failing to comply with his probation. Mr. McCray has a history, according to his family, who brought him to the gas station, of bipolar disorder, being paranoid schizophrenic, and at the time of the homicide, being off of his medications for nearly 2 months. As indicated, Mr. McCray came to the gas station. It was approximately 3 in the morning with his mother, the mother's boyfriend, with 2 sisters. Mr. McRae was in the station, attempted to pay for some merchandise. His debit card was declined, the app card was declined. It was a small amount, it was like $3.18, I believe. And in any event, Mr. McRae becomes highly agitated, and he's yelling and screaming, words to the effect, I'm gonna take this, pardon my language, take this shit, take other shit. And it's a really, it's a really, he's acting in a very aggressive manner. Now, it should be pointed out, initially, he's not acting in any aggressive manner towards the other patrons that are behind the glass of the station. His encounter is with my client. And my client is not yelling or screaming at him, but telling him, just put the shit back, put the stuff back, or either pay for it. And when Mr. Alassane locked the door, or Mr. Ayash locked the door, he did call 911 as trained. And while he's on the 911 call with the 911 operator, Mr. McRae is yelling and screaming. He's talking to Mr. McRae. He's not responsive to the 911 operator's questions, and she hangs up on him. The argument continues about whether or not he's going to pay for it or put the stuff back. And I've watched the video ad nauseum. It's probably about an 8 to 10 minute video. I've watched it ad nauseum the past few days. Contrary to what the witness statements say, at no time do I ever see in the videos, and I've watched it probably 30 times, hear the shooter say, unless you unlock that door, I'm going to shoot everyone in here. Now, he does threaten my client, but in terms of the patrons and Mr. McRae, they're kind of presenting a united front, like, unlock the door and let us out. Because the patrons, probably rightfully so, are saying, we have nothing to do with this, we just want to get out of here. You know, they were done with their business, done with using the ATM machine or whatever. Tensions seem to, I don't calm down, maybe too a strong of a word, but they tend to subside a tad. And then Mr. McRae has an outburst. He either throws a juice or water and throws it against something. The water comes out and it hits the victim that died. And after the water hits the victim that died, I believe that victim was there with his brother or a relative. The victim that died approaches Mr. McRae and calls him a girl and is, I guess, rightfully upset that he's hit with this water. And it's at that point that the shooter starts shooting. And he kills the individual that the water went on, and he shoots 2 other patrons. Now, the door is unlocked, and it's unclear, and I haven't figured it out yet. There's some reports that indicate that it tends to be unlocked prior to the shooting. There's some other reports that indicate that it might be unlocked after the shooting. I'm not 100% clear of that, but the video does reflect my client after the door is unlocked. And it appears before the shooting saying, go get out of here, but using an explicit, he goes, go on and get out of here. But the shooting happens momentarily right after that. After the shooting, Mr. McRae leaves. He gets in the expedition with his mother, I believe either her boyfriend or one of his sister's boyfriends, maybe a sister or 2. It should be noted that the boyfriend, while they were locked inside, came up to the door, attempted to go into the station, saw that it was locked, and then came back and told everybody in the expedition, it's locked, something's going on. Shots were heard, he came out, and Mr. McRae's mother ultimately indicated that when the shots came out, I think she acknowledges that they knew Samuel did the shooting, or Mr. McRae did the shooting. They drive off, and down the road, I think the police at least allege in the investigators report where they requested a warrant for the mother and the sisters and the man that was in the vehicle, that they obstructed the investigation. And they sought to charge him with accessory after the fact, but that was my client's involvement after the shooting. He was interviewed by the detectives, he cooperated. And then a written statement was taken at, I believe, 6 o'clock in the morning. This happened at approximately 3 o'clock in the morning, where my client acknowledges that he locked the door. And he gives a written statement and he fully cooperates. goes back to his house where he lives in Dearborn Heights. He's there, and he's ultimately arrested at his house. I don't believe the issue in this case is a risk of flight. Mr. Ayash has strong ties to the community. He has a wife, he has a child that went away. He has his mother, father, siblings. He has a good relationship with them all. And all he's wanting to do is get back into college and take care of his family.
Does he have a passport?
Does he have a passport?
Oh, Your Honor.
He does not, Your Honor. So he's not at risk of flight. In terms of danger to the community, there are conditions that the court can impose to minimize any danger to the community. The prosecutor argued before Judge McConaughey, well, you got to look at the prior road rage incident and where he's charged with felonious assault, felony fire. And yes, it should be a factor that he has that case, but he's timely appeared. And this isn't a case like Mr. Ayash was out looking for trouble. This is a case where he was at his place of employment doing what he was trained to do, albeit that training is certainly questionable. But he's 22 years old and, he's just doing his job. The video, was he disrespectful to the customer? Absolutely. And he should have listened to the innocent patrons. But there were no threats that the shooter was going to kill them. And given the shooter's mental health issues, door locked or unlocked, anything could have triggered him. And in this case, what triggered him was the deceased taking a step towards it. But getting back to the conditions about bail, there are conditions that the court can impose rather than a high monetary bail, which only serves to punish and keep Mr. Ayash in jail. And that is, the court can impose a GPS tether, the court can impose home confinement, and the court, it would be reasonable to do that at least till the preliminary examination when the court hears all the facts and makes a legal determination about what transpired. And if it even is a crime, this is a novel theory. And it's not like the typical manslaughter case or any type of other typical crime. It's a novel theory where the prosecutor's office is saying that it's certainly foreseeable if he locks the door and there's an irate customer, that it's foreseeable that the irate customer is going to pull out a gun and start shooting everyone. I don't think that that's the basis for charges. But in any event, that's for another day. I'm asking the court to set a reasonable bond with a 10% provision, with the terms of home confinement, with the terms of a GPS monitor. I do have adults here who are truly adults, over the age of 40, that have gainful employment, that say that they're willing to act as a third-party custodian, and would tell the court that if he violated any of his conditions of bond, they would be the first to report it to the court or the prosecutor. Bail is not to punish, and that's the bail set here is, I think, excessive, and I would ask the court to set a reasonable bail that takes everything into consideration. Thank you.
People?
Your Honor, on behalf of the people, I would oppose any modification of the bond at this point. And I want to focus in on one particular factor, and that is the defendant's demonstrated danger to the community, not just in the context of this case, but in a broader context. With respect to this case specifically, there are a couple of facts that I want to highlight about the sequence of events as described by Mr. Guy. First is that as this incident unfolds, I believe that Mr. Ayash is the first one that injects an element of disrespect into the situation and escalates the situation by calling the eventual shooter slow in the course of the argument that they were having. Second, the timing that he locked the door is pretty critical here, because the timing that he locked the door is right after the shooter made his intentions clear. And yes, the threat that the shooter made was to Mr. Ayash, but he made clear that he wanted to put his brains on the floor, that he wanted to kill him. And it's in that context when Mr. Ayash decides that it's somehow appropriate to lock that man in who's threatening to take human life in with 3 innocent customers who have nothing to do with the situation.
But the threats were directed to him,
They were directed to him.
not to the customers?
Correct, Your Honor.
Okay.
Now, after that, while the customers are locked into the store with the eventual shooter and everyone's essentially begging and pleading to be let out, it's at that point that
How long did this take place?
they were all locked in for approximately 5 minutes.
So there's this ranting and raving going on and threatening for 5 minutes before the shooting takes place?
Yes, Your Honor. So during that context of
Was the gun out exposed?
the gun was not exposed, Your Honor. During the argument that ensued, there are multiple points in time in which I believe Mr. Ayash's conduct is essentially geared toward provoking or escalating the situation. After he locks the door, for instance, he keeps saying, like, where are you going? Where are you going? As though he's provoking him. You can't get out. You can't get out at this point. While he's on the phone with 911, he does call 911, but he doesn't even really speak to the operator. All you can hear in the background is Mr. Ayash saying, put my stuff back or put my shit back repeatedly, and then the operator ultimately hangs up on the phone. So there's no real effort to try to get police there on the scene to deal with it. Throughout all that, Mr. Ayash makes threats back to the shooter saying, I'm not worried about your goofy ass, I'll smoke you. So there's a threat there. And as Mr. Gonick mentioned, one of the customers did indicate in his statement that the shooter allegedly said something to the effect of, if you don't unlock the door right now, I'm gonna kill everybody in the store. And to my ear, I do not hear that in the video. That being said, the audio quality of the video is not particularly high because of all the yelling and screaming. There are portions of it that are simply inaudible, where you can't hear what exactly is being said. But that was the statement of one of the customers that the shooter specifically said, if you don't let me out, I'm gonna kill everybody in the store. The other factor is that the door, from my understanding of where the investigation landed, is that the door was in fact unlocked before the shooting happened, about 15 seconds beforehand. But when it was unlocked, Mr. Ayash did not make any sort of express reference that, hey, the door's unlocked, everybody get out. Instead, he was yelling something to the effect of, I believe his words were, get the fuck on, and motioning, but it was in the context of everybody arguing and things had spiraled out of control by that point. The other thing that's interesting is once the homicide detectives arrived on scene sometime later, there had to be 2 interviews with Mr. Ayash. In the first interview, when he sat down with, I believe it was Sergeant Todd Eady, Mr. Ayash did not volunteer that he locked the door. That information came to the attention of the homicide detectives, and they later confronted him with it and took a second statement from him where he did acknowledge that he locked the door. But I think that highlights the cooperation here level was not quite at the level that I think Mr. Gonick believes it is. And so what we have here is a situation where, obviously the theory is he escalated this situation unnecessarily in an adversely negligent way that led to the death of somebody. And, the analogy that I think of is that, he's essentially got a bull raging through the China shop, and his response is to lock innocent people inside the store with that bull. And so therefore, it's very foreseeable that those people are going to get hurt. That something is going to happen.
How does any of that make him a danger to the community?
Well, Your Honor, the danger to the community is highlighted by, first of all, the way in which he escalated this unnecessarily, and second of all, in the broader context of his track record. Now, as Mr. Gonick mentioned, he is on bond to Judge Knapp for a felonious assault case. That's another situation where, based on the allegations, he allegedly escalated another petty situation to the point of threatening violence. And in that particular case, it was a road rage situation with someone who, my understanding, was a stranger to him, where he allegedly pulled a gun and threatened this individual. When the police responded, they recovered a gun. The gun was described by the victim as having a very specific set of characteristics, including a green laser pointer, and that was consistent with the gun that was recovered from the defendant. And this incident happened just in March. Now, aside from that, I pulled his CCH, and he has, by my count, 9 different contacts with the criminal justice system over his short life.
What's the nature of those contacts?
So if I can go through them, and most of these have either been dismissed or resulted in some form of slap on the wrist.
Understood.
But there was a 2017 charge for misdemeanor assault and battery out of Hamtramck that was dismissed. There was a 2019 charge of driving while license suspended, along with larceny of less than $200, which were both dismissed. There was a 2016 warrant request from Hamtramck Police, felony for arson that, based on the lack of information here, I assume was not signed. There was a 2017 another warrant request that I believe was not signed based on the lack of information for it was a felony level assault, but it looks like it didn't go anywhere. Then we have his 2023 case for which he's currently on bond. There's this case, there's 2 cases for which he was placed on PIDA. One was a misdemeanor narcotics case. The other one was a felony narcotics case. He got PIDA for both of those. There was another case for which it looks like he was charged out of Ohio.
That's fine. Let me short circuit this. So I would presume that you brought all this information to Judge McConaughey at bond redetermination hearing that was set shortly after the arraignment. Did you not? What circumstances have changed from then till now?
Okay, and that's a good question, Judge. I think there's one big thing that's happened. As you can see, my client is approximately 5'4", weighs 125 pounds. After the bail determination before Judge McConaughey, he's taken back to the Wayne County Jail.
Step back to the.
Oh, I'm sorry. He's taken back to the Wayne County Jail. And when he's taken back, several guards have made comments to other inmates. This is the guy who's responsible for the shooting of those 3 individuals and the homeless or whatever, which has really created a real difficult situation in the jail for him. Number 2, I also believe, Judge, under the consent decree with the loss of the ACLU, that part of that is at any point in time, a judge can reconsider de novo bail without a change in circumstances. And the other change that I want to highlight is after the bail redetermination hearing, I received the discovery of the case, and the discovery is quite voluminous. And in terms of the discovery, it does point out that there was this patron that was ultimately the deceased that was struck with the juice that did take steps towards Mr. McRae. And Mr. McRae thought that he was in fear of being hurt from this individual and started shooting. Now, Mr. McRae.
I can see shooting that person, but why did the other 2 people get shot?
Why did the other 2 people get shot? I think one of them also stepped towards him, and Mr. McRae just went off and started shooting. Mr. McRae has a history by his own mother's account of being a paranoid schizophrenic that my client didn't know. And
your client is safe behind bulletproof glass and he leaves these other people allegedly out there with a person who's wielding a gun and talking about shooting and killing people.
He's not wielding a gun though. My client never saw a gun until he pulled it out. And then that's when he unlocked the door. Now, in terms of the lack of his lack of cooperation that the prosecutor kind of alludes to, that's just nonsense. My client gave a statement at 6 o'clock that morning, a written statement to Detective Eby, indicating that the door was locked. He also attended a lineup where he picked out the shooter.
let me ask you this. Judge McConaughey set this bond, you said 100,000 cash, surety?
Yes. No, just 100,000.
100,000 cash?
Yes.
Okay, so how can I, as a judge sitting equally on this bench, overturn his bond?
Pursuant to the consent decree, this court entered into with the ACLU.
That's when it goes from magistrate to judge.
No, it also indicates that at any time the judge can review the bail demand. And I think the change in circumstances about what happened in jail, the discovery being revealed. I mean, if you want to start pointing fingers, I mean, frankly, you can point, and they were pointing at Mr. McRae's family, but for whatever reason, the prosecutor's office didn't decide to issue charges against them. But also the Wayne County Prosecutor's Office for a couple of years ago, giving Mr. McRae probation, knowing his history. So, I mean, I think, what I'm saying.
No, I didn't say anything.
Okay, I think under the consent decree, you have the authority to change the bond with the change in circumstances. And even if there was not a change in circumstances, and I think that the condition of a tether or a GPS monitor and home confinement until the court hears, this court hears the facts of the case, would be a reasonable condition. And the narcotics convictions, I just want to address that, it was for marijuana.
People, anything else?
Your Honor, I would just add that if there are any specific concerns about Mr. Ash's safety at the county jail, I do believe we could probably arrange some sort of swap in custody at both county.
So your primary reason for asking the court to keep the bond where it is that it poses a danger to the community?
That is correct.
And you base that based on the case that he has pending?
Based on the case that he has pending and this case, which taken together, I believe reflect somebody who has a tendency to escalate, which should be trivial situations, into situations that have resulted in violence and in this case, death.
Okay. Give me 1 second. Our so-called crack jack legal team of the court, because I wanted to make sure that I did in fact have the authority to change the bond. And according to them in current case law, I do. Contrary to what I believed at first. So the thing is, the purpose of bond is not for punishment. The purpose is to ensure that the defendant shows up in court, does not pose a flight risk, and does not pose a danger to the community. I don't think anybody is asserting that he poses a flight risk. I haven't heard anything. I can impose things to ensure that he does not impose a flight risk, such as house arrest, tow, and the like. Bigger question is, does he pose a danger to the community? So although he has this prior felony of felonious assault, felony firearm, on which he was on bond for, and I usually don't look very favorably upon someone who violates their bond it's not a situation where he violated it because he himself had a gun or he himself did something to violate the bond, other than in this case, locking the door when he shouldn't have. We'll save that for another day. We'll save that for the preliminary examination, whether he should have or shouldn't have, or should be found legally responsible for doing so. The prior felony he has, well, he's on bond, so whatever judge that case is before saw fit to let him out on a bond, and that bond has been, that case has been addressed through that particular bond. I think I would feel a lot differently if this defendant had done something aside from being in a store and locking the door when perhaps he shouldn't have. If he had, and even instigating the matter. If he was waving a gun around or something to that effect, or if he violated his bond conditions by being in possession of a gun or getting in a fight, even, or doing something other than acting grossly negligent, which is what the allegations are here. And although we may, at the end of the day, detest his decision to do what he did, or allegedly did, we could be pretty upset with him for not being concerned about other people in that store while he's behind the counter, safe, behind bulletproof glass. We're getting into the meat of the very issue here. Not necessarily whether or not he poses a threat to the community. I haven't really heard anything to sway me that he poses a threat to the community, or if I shouldn't place him on a bond that involves house arrest, where his whereabouts are known at all times, his movement is restricted. Not here to punish him at this juncture of proceedings. That'll come later if it comes at all. So I think that the bond is excessive. Even though this defendant picked up this charge while being on bond for another charge. The violation is not of the sort that warrants this court putting a bond on him this high and $100,000 cash. So the court is going to set bond at $100,000, 10% GPS tethered house arrest. Sure, it's not a popular decision, but I'm not in it being popular. Thank you.
While we're here, I guess it makes sense to just have a PCC today.
It does.
The shooter's exam was set for June 6th, and because the proofs are going to be different, and I don't think it makes sense to have the two of them sitting in the same courtroom together. My intention would be to ask for a different exam date than that one. If the court's okay with that.
I can do it as early as June 1st if you like.
Judge, to facilitate my client's family watching the YouTube video, they have to use my phone hotspot. And I run out and get it out. What time is the court looking at on June first?
June first, I can do it at 10 o'clock or 11:30. Or even 1:30.
Can we do it at 10 o'clock?
That's good. All right. June first at 10 o'clock.
And if I can inquire, because a lot of this is video based, if there might be a possibility of stipulations that all certain courts to testify to a video.
Oh, for sure.
Okay.
Okay, we just asked for stipulations. Is that what I just missed?
Yes, sure.
We're, I've seen all the videos. I'm not going to jump to the evidence or review the same. Okay.
I appreciate that. Thank you.
And Your Honor, there was one other matter, when the warrant was issued, I think it was accompanied by a motion to suppress the warrant in the system, just asking, now that we're here, if the register of actions can be made public.
Are you responsible for it being suppressed in the first place?
One of my colleagues was.
Okay, so sure. I think we can facilitate that.
Okay, and we'd like to keep the investigative report still sealed, just the register of actions.
All right.
Okay, thank you.
Thank you.
Thank you, Judge.
Mr. Cripps, you've been waiting so patiently.
Thank you.
Morning, Judge. Nice to see you.
Doing good, thank you. How are you?
Doing well, thanks.
Good.
Right here.
Scott Jr. Calling case 2259911, people of the state of Michigan versus Andre Scott Jr. Defendant is charged in count 1, assault with intent to murder. Count 2, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 3, felony firearm. Count 4, felony firearm. Harrison, go right.
Good morning, Your Honor. Matthew Kenny, P74079 for the people.
Hey, good morning, Judge. David Cripps, P34972, appearing on behalf of Andre Scott Jr., who joined us in court. Can you tell the judge your complete name, please?
Andre Scott.
Today is the date and time set for preliminary examination. Are we ready to proceed?
Judge, it's my understanding that the defendant intends to waive his preliminary examination today, and the people have no objection.
Mr. Scott and I have had extensive discussions about that in the Wayne County Jail last night. And it's our position that for today's purposes to waive the exam.
Mr. Scott, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one and you'll be bound over to Wayne County Third Circuit Court as you stand charged with complaint warrant. You understand that?
Yes, sir.
You understand the nature and the purpose of a preliminary examination?
Yes, sir.
You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit and there's probable cause to believe you committed it.
Sir.
Is anyone forcing you to waive your right? Does anyone promise you anything? Are you waiving your right freely and voluntarily?
Yes.
Any objection from the people?
No, Judge, thank you.
The court finds the defendant's waiver is made knowingly and voluntarily freely given. The court finds the defendant over to Wayne County Third Circuit Court Criminal Division for the proceedings. This arraignment on the information, date and time will be June 1st, 2023 at 9:00 a.m.
Thank you very much,
Judge, in relation to the bond, it's 100,000. I don't think there's a DSU report. Could you order one, please?
I'll refer to pretrial services for the bond recommendation.
Thank you.
Thank you, Judge.
Thank you. I'll be with you folks in one moment. Hey, you got that? How you doing?
I'm good.
Thank you so much. I appreciate you.
No problem.
Came right in the nick of time.
Your Honor, before we go off the record for Mr. Scott, I just want to confirm that the bond is $100,000.
It is, I see $1 million cash.
Yeah, I can't call it this. Thank you.
It's $1 million.
Okay, the register of action shows that. 100,000 must be there. Register of action.
The order I have from the court says $1 million cash.
Yeah, I think the co-defendant was lowered at one point. Perhaps the ROA is reflecting the co-defendant's was. The co-defendant has already planned and sentenced.
Okay. Well, whatever it is, pre-trial services are sorted out.
Thank you. Thank you, Judge.
Thank you.
He's up.
He's up, sorry.
Oh.
Sorry.
No.
Good morning, guys. How you doing? Do I have to? Wait, all you guys can wear it down? Okay, like that. Come on in. I just did.
Jones.
Okay.
That's on the wing.
Just old fashioned.
This book is Shanice and Kenneth.
Also,
I'm sorry.
So I'm not sure that's. Calling case 2356488, people of the state of Michigan versus Reginald Quentin Jones. Defendant is charged with count 1 homicide, manslaughter, statutory short form. Count 2 weapons, firearms, possession by felony. Count 3 and 4 felony firearm. Count 5 carrying concealed weapon. Appearances for record.
Good morning, Your Honor. My name is James Kehoe, and my P number is 82812 on behalf of people. Sitting with me today, Judge, just for the record, is our intern from the office, Ms. Rashali Shaw.
Okay, welcome.
William Glenn, PB 6794, on behalf of Mr. Jones. May it please the court, my client has 2 family members to leave, observe this proceedings.
Typically no, because we're actually technically still close to the public. And if I let defendants folks in and the prosecution folks in, then I have room for the people here.
Reginald Quentin Jones.
Today is the day time set for preliminary examination. Are we ready to proceed?
I believe there's going to be a waiver between the parties.
All right, we're waiving as charged.
No, but there's going to be one correction, Your Honor. Charge 1 is going to be reduced down, Your Honor, to careless discharge of a firearm causing death, and I have the act code if you would like it, Judge.
Yes, who is it?
It's 752.861.
752.861. Careless discharge of firearm.
Yes, Your Honor.
All right. Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. We understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one. You'll be bound over to Wayne County Third Circuit Court as you stand charged in the complaint warrant with this amendment to count 1 being careless discharge of firearms.
Yes.
You understand the nature and the purpose of a preliminary examination?
Not really.
Okay, so let me explain it to you then. If you were to have one, the prosecution will have to establish that the crime you're charged with was committed in the city of Detroit, and that there's probable cause, not proof beyond a reasonable doubt, but probable cause to believe you did so. They will do so by calling witnesses to come forth and testify as to what allegedly took place. At the end of the day, if I'm satisfied that the people have met their burden of probable cause, then I will bind it over to Wayne County Third Circuit Court, where you would be arraigned on the information which means you're told what you're formally charged with. From that point on, you would either schedule a trial or entertain any plea negotiations that may be available at that time. By waiving your preliminary examination, we skip that part about witnesses coming forth to testify, and I bind it over to Wayne County Third Circuit Court, where again, you'll be told what you're formally being charged with, and you can schedule a trial or entertain any plea negotiations. You understand now?
Yes.
Is it still your wish to waive your preliminary examination?
Yes.
Is anyone forcing you to do so?
No.
Has anyone promised you anything? No. Are you waiving it freely and voluntarily?
Yes.
Any objection from the people?
No, Your Honor.
The court finds defendant's waiver is made knowingly and voluntarily freely given. The court binds the defendant over to Wayne County Third Circuit Court Criminal Division for the proceedings. His arraignment on the information date and time will be June 1st, 2023 at 9:00 a.m.
May it please the court, as to bond.
Okay.
Right now, the present bond is $150,000 cash. Now that we have a very substantial charge reduction as a count one, we would ask the court to entertain a personal bond with the GPS tender.
Mr. Keto?
Given the changes of the charges, I leave it to the court's discretion, having had ample opportunity myself to review all the evidence in this case, which I know the court has not had the opportunity. The video itself is pretty clear as to the facts and circumstances of what happened in this case. And I think that given the charges as they stand now are much more appropriate, so I would leave the court its discretion.
Do you have any strong objection to a personal bond with the defendant?
No, not strongly, Judge.
Okay. Court set bond at, what is the current bond?
It's $150,000 cash.
Court set bond at $150,000 personal bond with a GPS tether. Are we doing house arrest?
Yes, please.
House arrest. Okay. I need a bond reduction.
Thank you, Your Honor.
Thank you, sir. Have a good day.
You as well, Judge. Thank you.
You just have to keep right there.
Judge, may we approach briefly?
Yes, sir. Yes.
How are you?
So you prosecutor's office? You take anybody? Oh, how you like? One more? It's strange watching. Okay, well, actually, I got news for you because if you got approached you,
Ma'am, the case
was postponed, adjourned to another day. I'm gonna find out the date. Okay. You can wait for me in the hallway. Come. Is this okay with you, sir? Okay. All right. Thank you. Okay.
What, tell them what you did.
You think the attorney's still out there? You think the attorney's still out there? Or the prosecutor? You think they're still out there? But I mean, you keep one copy. Or the attorney. They do that. So I make a copy. I think they are.
I know you need, you got yours. Okay.
He'll testify. So I turned all 3 kids, including his younger brother, into testify. It turns out that the kid went to Jackson State, Tennessee. I'm an old guy. I have more reasons. Crazy, money crazy, or crazy. Crazy, crazy, crazy. So, maybe it's like he was robbed. Right into his house. He's not there. He's waiting.
Wait.
We're gonna have, I think one of the time we had. Yeah. No, we can get some pictures. You gonna take it? I need you. Thank you. Show me how to do it. Okay. Come on, y'all. Take it right here. She coming. Going in. Come on, y'all, we'll go in there and take it. Yeah, right here. You got all of us? Okay. What about that? You got me? Or did a bag up? Okay. Okay. Oh, I like that. I like that. I like that. I like that picture.
No signs, no hand signs, no
Okay, I
hand
know.
signs, nothing.
So you send it to them and
You know, hands down, hands down.
yep, that way you can send it in. That'll work. No figures, y'all.
No sign, no hand signs.
We can send it to the guys in prison with no figures.
Right. Sure. I'm looking for your hand sign right now.
I got another.
Ready? You carry my, come back here.
Michael trying to get you.
You put your hand behind their picture, and we cannot send that picture. We can use it in the school, newspaper.
Michael Jordan signs me.
Hey, say that's what they call everybody.
Hey, what did the girl say to, asking how was his day? And that's what the dog was saying.
Hey, y'all got to thank the judge. Thank you, Judge. Thank you, Judge. Yeah, we'll come up.
I see you again, we gotta bring another set of keys.
All right, let's go. Nice to meet you. Nice to meet you.
Let's see that picture. Oh, yeah, he is. Yeah, he's spoke. Yeah. Yeah, that's right. He will,
Okay. Calling case 2355755, people of state of Michigan versus Leroy Frank Matoyer III. Defendant discharged in count 1 felony murder, count 2 child abuse, first degree. Appearances for the record, please.
Good afternoon, Your Honor. Tina Ripley on behalf of the people, P83688.
And good afternoon, Gabi Silver appearing on behalf of Leroy Matoyer.
Tell me your name for the record, sir.
Leroy Frank Matoyer III.
The date and time set for preliminary examination, we're ready to proceed.
Yes, Your Honor.
Yes.
How many witnesses for the people?
Just one.
Do you have any preliminary matters you'd like to begin before you call your witness?
I would just, we asked for the motion to sequester, including the one YouTube patron from last time.
Who is that?
I believe it's Danielle Thornton.
Gordon? Okay.
And any others, I guess.
Yeah, well, of course.
Ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, including Ms. Ivory Thornton, I'm ordering you to log off at this time. To remain on this and view these hearings, you may be preventing yourself from testifying in a future date. Anything else?
People call Erica Adams.
Good afternoon, ma'am. Please step forward, give your name and spelling of your name to the young lady seated over there.
Erica.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please have a seat. The witness box right up here next to me. Voice up nice and loud and speaking to that microphone that's going to be to your left. Thank you. Ready.
Thank you, Judge. Good morning or good afternoon. Could you please state your name for the record? Erica Edmonds. And Ms. Edmonds, did you have a daughter named Justice Starks? Yes. And what was her birthday? 12/27/20. And how old was she when she passed?
I'm sorry.
Well, that she was about to turn 2?
Yes.
Did something happen on November 29th of 2022?
Yes.
And can you tell me what happened?
Leroy called me across and told me that he was just stuck on the set. He showed her on FaceTime and she was fun. She didn't have her eyes open. Her mouth was open.
So you said Leroy. Who is Leroy?
Leroy was very.
Can you just point to someone in the courtroom?
Yes.
Can you tell me what they're wearing?
Very nice.
Your Honor, was the record reflect the witnesses identified the defendant?
So no.
Thank you, Judge. Can you tell me about your relationship with Leroy Matoyer?
Yes, we were dating at the time.
And on 11/29/2022, who did you leave justice with?
Leroy.
Would it be fair to say that Mr. Matoyer had care and custody over justice at that time?
Yes.
And where did you leave her at with Mr. Matoyer?
I can remember this, but it is the same gesture.
And
I'm sorry, I didn't hear you.
I can't remember his full address. I think it was 19230 Lancashire.
is that in the city of Detroit?
Yes.
About what time did you bring justice to Mr. Matoyer?
11:45 a.m.
And what did you do after that time?
I made sure she was situated. After I left, I went and got something to eat and proceeded to my grandpa's house.
And while you were away from justice, did you ever call or talk to check in on her?
Yes, multiple times.
And about how often did you do that?
It was about 2 or 3 times.
And how many times by phone call?
Either 2. It was 2.
And is that a voice call or a FaceTime call?
Both.
Okay. How often would you text?
Very often. Probably about every other hour. When she was living.
And did Mr. Matoyer ever give you updates on justice?
Yes.
And what would he say to you?
He was saying that she was a little fussy, and that she was laying down, but I asked to see her on FaceTime.
Did he ever say how justice was acting after you left?
He said that she freaked out, was fuzzy, was going to fit.
And did you ever try to help Mr. Matoyer with getting along with justice?
Yes, he was very strict at times, so I was telling him at that time, like bond with her, color, play with her.
Did you ever tell him not to do anything to justice?
I told her don't. Just, I know he would like to discipline her, but don't discipline.
And the word discipline, how are you using that term?
Not physically, but telling her right now, like, you know, everything.
So I'm gonna take you back to the beginning of the day on November 29th of 2022. Tell me what you did when you woke up.
Me and her woke up around 9 or 10. I fed her breakfast. We colored, played. I gave her a bath. Then I got her dressed to head over to my people's house.
And how was she acting when you dropped her off?
She was in a place when she was happy. Once she knew I was leaving, she was getting a little sad and fuzzy. And I thought I was because I was around her next time.
And how was Justice's health when you dropped her off?
She was fine. She just had a mark on her hand. That was good.
And when you say a mark on her hand, when you approach it, it's 30 and 31. Yeah, go check.
Ma'am?
I mean, you can go propose exhibits 30 and 31. Tell me what goes on that I just handed you.
Pictures of her hand.
And are those pictures fair and accurate pictures of what her hand was like the morning of November 29th, 2022?
Yes.
That would be a picture of people's 30 and 31.
Any objection?
I do. I'd like to know who took the photos and when they were taken.
I mean, so you're gonna ask for the admission. Well, I don't think that it goes to the admission of the photos, I think it goes back on them. We know that certain photos that don't have to be taken by the person who admitted them.
That's true. The objection is what? What's the legal objection?
I'll wait, Judge. I'll cross examine.
May I proceed?
Are they getting judged?
Yes.
Thank you. Was it anyone else at Mr. Matoyer's house when you dropped off Justice?
No.
And you said that after you dropped her off, you were going to get some food and go to your grandmother's house.
Yes.
And where were you going to go after your grandmother's house?
Going to work.
And what time did you get to work?
I got to work at 3:05. I sat in my car until 3:25.
And why did you sit in your car until 3:25?
I was on the phone with my friend at the time and I was contemplating on whether to go in or not, because I just didn't feel like going. And he was just talking me out of calling on because I was already there.
Why were you, I guess, how were you feeling about going into work?
I just felt like something bad was going to happen.
And about how long were you in work for?
Not even 10 minutes. I got the call at around 3:39 from we were saying that they thought that I needed her again.
So this FaceTime call is, you said it's FaceTime call?
Yes.
Okay. And that's around 3:39 on November 29th.
Yes.
And tell me the first thing you see when you get this FaceTime call.
Everything I seen was we were yelling to the phone, saying I needed her to come quick, telling Justice got on the steps. And then I seen Justice at the bottom of the steps, and she was just, one of her eyes was closed, mouth open, but she wasn't looking.
So when you see Justice at the bottom of the steps, is she laying on the steps or is she in his hands or something else?
She was in his hands.
Okay. And where are they at in the house?
The bottom of the steps.
Did you see anyone else
No.
in the house at that time?
No.
Did you hear anyone else in the background?
No.
When you said you talked to Mr. Matoyer a couple times on the phone between when you dropped off Justice Select until 3:39. Is that correct?
Yes.
During your phone calls and FaceTime then, did you see or hear anyone else in the house at that time?
No.
So tell me a little bit about Justice's relationship with Mr. Matoyer.
She was playful with him. She wasn't as clingy as she was with me as she was with him. He would say that I spoiled her too much because she would walk around the house and follow me everywhere. And he used to reiterate that she needed to be more entertaining.
Did Justice ever seem scared or afraid of him?
When he would be strict with us, like telling us to eat with our hands at the table, she didn't like that.
How would she act? Would she cry, scream?
She would cry when he would say it.
What about when you would leave her with Mr. Matoyer?
She just seemed sad because she knew I was leaving, but she would never scream on top of her lungs.
Tell me how long that you and Mr. Matoyer had been dating as of November 29th, 2022.
We started dating in August, so that is 3 months.
That's August of 2022?
Yes.
And how long have you been watching Justice?
Started watching Justice November 14th.
When you first met with Detroit police on November 30th, it'd be fair to say that you told them something different.
Yes.
About when or how long you guys have been dating and how long you've been watching Justice?
Yes.
Why is it that you told them something different on November 30th?
Because we were threatening me. He told me that he would fucking kill me.
Said what?
He told me he would fucking kill me if I wouldn't follow his lead.
So he wanted you to lie about.
Objection leading.
Sustained.
What did he want you to lie about?
He told me in the waiting room that this is making him look bad and we need to tell him that we were dating because we were friends.
I'm sorry. Sure, but I'm not, never mind. Okay.
Tell me about your relationship with Mr. Matoyer.
My relationship is okay.
Was he ever strict or?
Objection, Judge, now she's leading. The witness just answered, our relationship was good.
Mrs. Singh,
Thank you.
you heard.
How would you describe your relationship with Mr. Matoyer?
Objection asked and answered. She said it was good.
I asked how it was, I didn't ask. It's a different question, Judge.
It's the same question.
Can you describe your relationship with Mr. Matoyer?
It was okay. At times he was strict with us. Like I said, he would always leave with our hands on the table. We would have to wake up at a certain time and go to sleep at a certain time. He used to always tell me not to have justice follow me everywhere.
Would he ever try to parent justice?
Yes.
And tell me about that.
He would tell her that she couldn't eat certain things, eat at certain places of the house, that she couldn't wash shoes at certain times.
And would he ever try to control your parenting justice?
Yes.
Tell me about that.
He was saying that she was being too clingy, she needed to be more independent. He was also talking about her relationship with me and her father. He was saying that she needed to be more advanced than what she was.
Was Mr. Matoyer ever physically abusive to you?
He did leave marks on me when we did have sexual intercourse. And then I would bring it to his attention, he would never acknowledge it.
I'm sorry, can you repeat the last thing you said?
Yes, he would leave marks on me during sexual intercourse, and I would send him pictures of it, but he would never acknowledge it.
Was he ever mentally abusive to you?
Yes.
Tell me about that.
He was just saying how I wasn't doing much with my life. I should have been doing more. I could have been a better parent. And then work-wise, I could be doing more than what I was doing.
Did you ever stay at Mr. Matoyer's house with justice?
Yes.
What were the sleeping arrangements at his house?
I would sleep with him when she was sleeping in the bedroom all the time.
Is there a heater in that guest room?
Yes.
I'm gonna approach with proposed exhibit 32.
Okay.
Can you tell me what I just came?
The heater that's in the guest room.
Is that a fair and accurate depiction of any of the actors that justice stays in?
Yes.
Your Honor, will refer to the exhibit 32.
Any objection?
No objection.
Admitted.
And for the bedroom that you stayed in with Mr. Matoyer and the guest room that justice stayed in, is that upstairs, downstairs, or something else?
It's upstairs.
Your Honor, may I go to the proposed exhibits 34 through 37?
Yes.
Can you tell me what I just need?
A picture of the stairs.
And is that multiple photos?
Yes.
And do those photos fairly and accurately depict the stairs that are in Mr. Matoyer's house that lead to upstairs and bedroom stuff?
Yes.
And I believe the information of exhibits 34 through 37.
Any objection?
Judge. Can we have a moment outside the presence of witness?
Okay. I'm gonna have you step down just for a moment, so you can stay in the court.
don't know what it's- I don't know. And I'm just bringing it up. And I don't know. It's not- Oh, so I don't think that's what Sarah was watching.
Thank you. Can we take a stand? Let me remind you that you're still under oath. All right, ladies and gentlemen out there in YouTube land, I know you're watching. It's been brought to my attention that there may be some people that are watching that should not be watching. Again, if you are a potential witness in this matter, you are to log off at this time. I am ordering you to do so. If I find out that you have not done so, you continue to watch, you run the risk of even being held in contempt of court. Do I have some specific names of people who should not be on the
Father,
What's
mother,
father's name?
Janarius Starks,
Janarius Starks. If you're on, I need you to log off immediately.
Mother and grandmother's lawyer,
Mothers,
grandmother's justice,
what's the name?
grandmother's of justice Starks.
Grandmother of Justice Starks. You are ordered to log off at this time.
That's it.
Okay. All right. Thank you.
Thank you, Judge. And I believe I was the admission of 34 to 37.
And I have no objection.
Admitted.
Thank you, Judge. And those photos of the stairs that I just showed you, are those the same stairs that you had seen Mr. Matoyer at the bottom of when he FaceTimed you?
Yes.
As for that heater in Justice, in the extra my Justice Station, where is that at in the room?
It's by the window.
And is it sitting on something or on the floor or something else?
It's sitting on the floor.
And do you know how hot it gets?
It gets pretty hot.
How often would you and Justice stay the night at Mr. Matoyer's?
We spend the night about twice a week.
And when did that start?
We started November 13th or 14th.
And how often did Mr. Matoyer watch Justice?
He started watching her on the 13th, and that'll be about once a week.
$13 of what month?
November.
When is the next time that you saw Justice after that FaceTime with Mr. Matoyer?
At the hospital on the 20th.
And what hospital is that at?
Sinai Group.
And who was there?
It was myself, Leora.
And where were you and Mr. Matoyer at in the hospital?
In the waiting room.
And how is Mr. Matoyer at?
He kept pacing back and forth, acting hysterical, but there wasn't any tears in them.
There wasn't any what?
Tears.
Was he saying anything?
He just kept saying how sorry he was.
Did you ever say what he was sorry about?
That this happened.
Did you notice anything physically wrong with Mr. Matoyer at that time?
No, he was pacing back and forth.
Did he complain about being hurt or anything hurting?
No.
Was he walking normal?
Yes.
And what happens in that waiting room at Sinai Grace?
He told me to give him a hug, he pulled me in a corner, and that's when he whispered in my ear that he looked up and killed me. I didn't follow the
And is it just you and Mr. Matoyer in the room at that time?
Yes,
And did you follow along with what he asked you to do?
yes,
Why did you do that?
I was afraid.
And you went and talked to Detroit police again on December 1st. Is that correct?
Yes,
Yes. And why did you go and talk to them again?
because I was ready to tell the truth. I didn't care about being killed at that point.
And what did you tell them the truth about?
How long me and Leroy was dating, and how long he's been watching Justice.
And what did you tell them about how long you two had been dating?
I told him we were dating about 3 or 4 months.
And how many times did you tell them that you watched Justice?
About 4 times a month.
And that was starting, I think you said on November 13th or 14th?
Yes.
Okay. So we're gonna go through those times that you watched Justice. Before we do that, on November 29th, you said you went to Sinai Grace Hospital.
Yes.
Were you eventually transferred to a different hospital?
Yes.
What hospital was that?
Children's Hospital.
And did you see Justice when she was at Children's Hospital on November 29th?
Yes.
Did you get the chance to see the condition that she was in?
Yes.
Did you get to see all of the bruises and injuries that had happened to her?
Yes.
And I may I approach those proposed exhibits?
Yeah.
Forward through 14?
Yes.
Can you tell me what it is?
The pictures are Justice injuries.
And are those photos fair and accurate depictions of the injuries that you saw on Justice at Children's Hospital on November 29th, 2022?
Yes.
As with the admission of the proposed exhibits 4 through 14.
Any objection?
No objection.
Admitted?
Thank you, Judge. And 11, these injuries that you saw on Justice at Children's Hospital, November 29th. Had you seen those injuries on Justice before you dropped her off at Mr. Matoyer's house?
No.
So now I'm going to go through the times that Mr. Matoyer watched Justice. So you said starting November 13th, you guys stayed the night?
Yes.
What, if anything, did you notice, or did you notice anything wrong with Justice after Mr. Matoyer had watched Justice on the 13th?
Objection, that's not what she said. She said that they both spent the night on the night of the 13th.
Were you there though? I'm sorry, I'll lay a better foundation. Were you there the entire day on the 13th with Mr. Matoyer and Justice?
Not the entire day.
And where did you go?
I went to work for a few hours.
And for those few hours, was Mr. Matoyer watching Justice?
Yes.
Thank you. So when you got back from work, did you notice anything wrong with Justice?
Yes, when she woke up in the middle of the night, she had a cut on her lip and, cut on her head.
And did Mr. Matoyer, ever give you an explanation for those injuries on Justice?
Yes, he said that she hit her head on the futon.
And when is the second time that, Mr. Matoyer watched Justice?
He watched her in November 21st.
21st?
Yes.
And that's a Monday?
Yes.
And what happened on the 21st?
The daycare called and said that she had a fever of 103 and that she needed to be picked up. Leroy drove me to go pick her up and, she was really, really fussy. She was crying nonstop. We get a fever rate. And then he watched her. And then that's when I noticed that she had the, marks on her.
Did he ever watch her on the day after?
Yes.
So the 21st into the 22nd?
Yes.
And you said you noticed, what did you notice about her after that?
She had a mark on her hand.
A mark on her hand?
Yes. And on the 22nd, I noticed that's when she had patches of hair falling on.
Okay.
And she had a scab around her nose.
Okay. And you said, the daycare called Justice was sick?
Yes.
Okay. Paramedic, we'll go to the 38 and 39.
You may.
So I just handed you.
Pictures of Justice here.
And are those fair and accurate depictions of how Justice's nose looked on November 22nd, 23rd?
Yes.
And is also fair and accurate depiction of the impact chair saw Justice was using?
Yes.
And who would be mentioned 39, 38?
Any objection?
No objection.
And it,
Yeah.
did you plan on publishing this to the court?
Yes, Judge, I was gonna do that, yeah, if you wanted. Did Mr. Matoyer give any explanation as to the redness on her nose?
Yes, he told me that he was wiping her and blowing her nose with a paper towel, and that's what irritated me.
And the hair mixing on the back of Justice's head, how did you come to notice that?
I was washing her up and I was washing her hair and just fashion for her to start falling on. She was screaming.
And would that have been on November
22nd?
22nd? Okay. And what did you think caused the hair loss?
I thought because she was sick, it was part of her sickness, but she was not feeling.
And when is the next time that Mr. Matoyer watches Justice?
On the 29th.
How was Justice when you dropped her off?
Her nose was feeling, she still had the scab on her hand, but that was still pretty much.
Did she have any bruises on her when you dropped her off?
No.
There's nothing on her face or legs or back?
No.
And I believe you said earlier that morning before you dropped her off, you'd given her a bath.
Yes.
So it'd be fair to say that you saw Justice's entire body at that time.
Yes.
And you didn't notice any bruises?
Correct.
Where was Justice between November 23rd and November 27th?
She was with her father. That was his weekend for Thanksgiving.
Did Did you and Mr. Matoyer ever fight about justice?
Yes.
When?
When he was saying that she was being too clingy, that she was being more independent.
Judge, this has already been asked and answered. This is like the third time we get this go around.
Well, that was a different question, but the same answer to a different question.
I can deal with it. Did, you and Mr. Matoyer ever fight about justice, on November 28th?
Yes.
Tell me about that.
He was saying, because she was crying, that she needed to shut up, so me and him got in an argument about that. He was talking about my parenting skills, and then he was talking about how, I'm sorry, you said November 28th?
Yes.
Okay, that day we went to go visit my parents, and, she was eating a cupcake in the bed, and he was saying how happy she was, and how he always seems like the bad guy, because he's always disciplined. And, he was telling me that he knows that she can't eat in the bed, so why would I allow that for that to happen over there?
When you're saying we went to go visit at your parents' house, who's the we?
Justice and I,
Mr. Matoyer wasn't there?
no.
This would have all been via text or phone
Text
call?
message.
Text message, okay. And you guys had thought about her prior to that also?
Yes.
Was it always verbal?
Yes.
Who normally watches justice?
Either the daycare, my mom, or my grandmother.
Why not on November 29th?
Because she couldn't go back to the daycare because she wasn't 3 days, well, 3 days free without a fever.
Did Mr. Matoyer ever ask to watch justice?
Yes.
How often would he ask to watch her?
Very often. On the 28th, that's when he asked, did he watch her on the 29th?
Did you think anything of him asking to watch her?
No, he would usually ask about her little man most of the time.
How many times did he ask to watch justice?
I didn't keep count. I'm sorry.
Would it be more than the times that you had allowed him to watch her?
Yes.
Sorry, to backtrack a little bit. When Justice came home from her father's house for Thanksgiving, how was she?
She was fine. She just still had a little mark on her nose, I would say, and the mark on her knee.
There's nothing else wrong with her physically?
No, and I also sent a picture to Leroy on the 28th showing that she was fine when she was eating the cookie.
Your Honor, may I approach it? We'll just do the 40.
Sir?
May I approach it? We'll just do the 40.
Yes.
Demonstrative exhibit. Tell me what I understand.
The calendar of the times that you watch it.
And does that calendar November 2022, is that fairly inaccurately depict the dates and what you just described happened on each date?
Yes.
I think we're going to make it up to the 40.
Any objection?
No objection.
Okay.
Thank you. Nothing further at this time, Judge.
Cross-examine.
Yes, thank you. So, ma'am, as I understand it, you met Mr. Matoyer in August of 2022, is that correct?
Yes.
And you met him through some family members of yours, is that correct?
Yes.
And you actually began dating sometime maybe in October, is that accurate?
We were dating in August as well.
Okay, so starting in August, continuing through November, were you in an exclusive relationship with Mr. Matoyer?
Yes.
Not seeing anybody else?
Yes. That's correct.
You weren't seeing anyone else?
No, I was not.
Okay. So when you began dating Mr. Matoyer, did you tell anybody else in your family that you were dating him?
My cousins Sherelle and Gabrielle knew.
Okay, what about your family, your mother, your father, your grandmother?
No. They
Why
haven't
did
met him yet?
I'm sorry?
They haven't met him yet during that time.
But you were spending nights over at his house.
Yes.
You were living with your grandmother at that time, is that correct?
Yes.
And so you were spending nights over at his house and taking your child with you at that time also, is that correct?
Yes.
And you didn't tell your grandmother who you were living with, who you were going to spend the night with?
No.
So you went to the police. Well, let's backtrack for a second. After the phone call that you received from Mr. Matoyer telling you that he had fallen down the stairs with justice, by the way, those stairs were pretty slippery, is that correct?
It depends on if you were in socks or barefoot. Yes.
Yeah, because that's what you told the police, that they were slippery and you in fact had slipped on them before, is that correct?
Correct.
Thank you. So you get a call from Mr. Matoyer, you head over to Sinai Grace, is that right?
Correct.
And when you get to Sinai Grace, you said that you went into a waiting room at the hospital, is that correct?
Yes.
And I would imagine at that point in time, you were pretty upset and scared. Is that a fair statement?
Yes.
All right, so you're in this waiting room and were you in the room by yourself?
No.
Who was in the room with you?
Leroy.
Okay, and who, did you get there first or was Leroy, did Leroy come after? How did that work?
We both arrived at the same time.
All right. Who told you to go into that waiting room?
The person walked us over there, the receptionist.
All right, and put you both into this waiting room?
Yes.
All right, and did anybody come in and talk to you at that point in time and tell you what was happening?
There was a registration lady that came in to get all our information for the health insurance. There was a social worker, and then that's when Detective Alexander came in.
All right, and so you said that Mr. Matoyer threatened you in some way at that time, is that right?
Yes.
Was that after the social worker and Detective Alexander came in?
That was before.
Okay, so before the police came in, and before any social worker came in, according to your testimony, Mr. Matoyer made some threats towards you, is that right?
Yes.
Okay, so at that point in time, nobody had confronted you or Mr. Matoyer about anything wrong having happened to cause this injury. Is that a fair statement?
Yes.
All right. So according to you, Mr. Matoyer tells you, tell us exactly what Mr. Matoyer said to you.
He said that he would fucking kill me if I would not call his lead.
Okay, and what was his lead? What did he tell you to do?
So I about how long we were dating, how long he was watching justice.
Okay, so he wanted you to lie and say that you had been dating for a year, right?
Yes.
Okay, because how would that have helped Mr. Matoyer?
He said it's making him look bad.
Well, how does it make him look bad Or does it make you look bad? Because you left your child with somebody who you'd only been dating for a few months.
No, it's not making me look bad because she wasn't with me, my presence when she passed away.
Well, I understand that, but if you've left your child with somebody who you've only known for a very short time, it's kind of your responsibility for your child's well-being, isn't it?
But it's not my reason to lie about how long we would be dating. I didn't have a reason to lie about.
Well, you never told anybody in your family about him, right?
Correct.
Did you tell Mr. Starks, Justice's father, about this new boyfriend and you were spending the night with him and Justice was staying there too?
No, he doesn't tell me about his girlfriend.
Okay, so were you nervous about him finding out that you had been spending the night with somebody you didn't know very well and leaving Justice with that same person?
No, I'm nervous.
So that's why it was more important that the length of time, that it looked like you knew him for a long time.
No.
You don't agree with that?
No.
Okay. So, when you talk to the police, you told the police the first time this story that you'd known him for a year, that you were dating for a year, and you told them during that same conversation, in fact, that you had only spent the night there one time. Do you remember that?
I don't recall that.
All right. So after that threatening conversation from Mr. Matoyer towards you, throughout that night and the next day, you received a number of text messages from Mr. Matoyer as well. Is that correct?
Yes.
And you would agree with me that none of those text messages were threatening in any way. Is that
I don't recall all those text messages that he sent me.
Yeah, you don't recall them?
I don't recall all of them.
Okay. Do any of them stick out in your mind as having been threatening?
I don't remember.
Did any of them say, hey, don't forget, follow my lead or I'm going to kill you?
I don't remember.
Would it surprise you to know that none of them were threatening in any way? That they were just expressions of concern over how you and Justice were doing?
I don't remember.
When you were at the hospital, well, strike that. After you got the phone call from Mr. Matoyer to come to the hospital, well, did he tell you to come to the hospital or how did that happen?
Well, I called him multiple times and texted him and he wasn't responding. When I was on my way to his house, that's when he called me when I was like 5 minutes away to meet him at Sinai Grace.
All right, because an ambulance had come and all that, is that right?
Yes.
All right. Did you call any other family members at that point?
No.
Did you didn't call your mom or your grandmother or anybody at that point?
No.
Did you call Mr. Starks, the father?
No.
How come you didn't do any of that?
I was just concerned about her condition at the time.
When you got to the hospital, after these threats were made to you by Mr. Matoyer, you said that social workers came in the room and the police came in the room. Is that correct?
Yes.
And did they remain in the room with you during the rest of that evening until you left to go to Children's?
Detective Alexander and the social worker didn't remain in the building, in the room with me during the night. No.
So was it you and Mr. Matoyer in the room?
At Sinai Grace, yes, until she was transferred to Children's.
All right. Did any of your family members come up to Sinai Grace?
Not Sinai Grace, the Children's Hospital.
Okay. So when you were at Sinai Grace, did you tell Detective Alexander and the social worker that Justice had fallen down the stairs at the home of Leroy Matoyer?
Yes.
Okay. And Leroy Matoyer, who lives in Detroit, is that correct?
Yes.
So when you get to the hospital, to Children's Hospital, other members of your family arrived, is that correct?
Yes.
And did you tell those other members of your family that Justice had been injured at the home of a family friend in Pontiac?
No, I did not say Pontiac.
What did you tell your other family members?
That she fell down the steps. With
Where?
Leroy.
Where?
With Leroy.
And is that what you told Mr. Starks, the father?
Yes, that's what I told him.
You never told anybody that she fell down the steps and was injured in Pontiac, according to you?
No.
So after this, she gets transferred to Children's Hospital. That was on November 29th at night, is that correct?
Yes.
And so at some point, you went to the Detroit Police Department and made a statement there, is that correct?
Yes.
And that would have been the first one you made would have been on November 30th, is that correct?
Yes.
And when you made your statement to the police, did you feel like the police were accusing you of having done something wrong?
No, I just know they were doing their job, which was to interview me and see what was happening.
All right. And on December 1st, did you go to the police or did they call you to come to them?
I went to the police office.
Okay, and who did you go there with?
My cousin.
And which cousin is that?
Cherokee.
And again, when you went to the police on December 1st, the police gave you your constitutional rights, is that correct?
Yes.
Okay, and they gave it to you the day before when you talked to them too, is that correct?
Yes.
So on that day, that was of course after Justice had passed away, is that correct?
Yes.
On the 1st, okay. And that's when you decided, well, you were gonna tell the police the truth being that you had known Leroy for 4 months, not for a year.
Correct.
Okay. Now, you told us that one moment. Oh, one other question. The prosecutor provided me with some pages of notes that she says were written by you. Do you know what I'm talking about?
Yes.
Okay, and it's about 6 pages long, is that right?
Yes.
And when did you write those notes?
After Justice passed away.
Okay, did somebody tell you to do that? Or did you want to just write down everything you could remember?
I took it upon myself to write down everything I could remember.
Okay, what was the point of writing the notes?
So I always go back to reference so I don't forget.
Okay, and what were the things that you were trying to write down so you wouldn't forget?
Every event that happened.
Every event in terms of?
Just everything, when we went on our first date, when we started watching Justice, incidents that happened.
All right, so according to your notes, the first time that you introduced Justice to Frankie was October 12th, is that correct?
Yes.
All right, and you also noted in your notes injuries that you had seen on Justice, is that correct?
Yes.
For example, a bruise on her eye on October 14th when she had been in the care of your mother, is that correct?
Yes.
And you called your mother and asked her about what had occurred, is that correct?
Yes.
And Justice had fallen off the bed and gotten bruised, is that right?
Yes.
And so Justice was kind of a restless sleeper, is that correct?
No.
She didn't move around a lot, fall out of the bed?
Well, that's what's not. Mostly babies move around in their sleep. So I wouldn't say she was a restless sleeper.
Okay, had she fallen out of bed before when she hadn't been in a crib?
She sleeps in a crib so now she can fall with it.
Okay, well, she fell out of the bed at your mother's house.
Yes.
And at Frankie's house, you had her sleeping on the futon, right?
Yes.
and you put pillows around so she wouldn't fall off, is that right? Or Frankie put pillows around so she wouldn't fall off, is that correct?
Yes.
That's what Frankie did, correct?
Yes, that's what Frankie did.
All right, and at one point, you told us that, well, we'll go back to that in a minute, sorry. You told us that you well, let's go back a second. After that incident where she had a bruise on her face from your mother's house, did you have a conversation with Janarius Starks about that?
Yes.
And he was angry, is that correct?
Yes.
He was angry because every time she was with you or your mother or whoever, she was getting injured, is that correct?
No.
That's not true?
Context of the text message.
Well, he said he was so mad and gonna put her in a bubble so she wouldn't get any more scars when she rolls off the bed. Is that what he was talking about with you?
Yes, but as a child, they fall, children fall.
You told us that there was a bruise on Justice's head or forehead around November 17th of 23, is that correct?
No.
I'm sorry, 22, sorry. I'm sorry? You don't remember, you don't remember? I'm referring to, well, in sometime in November, Frankie went out of town, is that correct?
Yes.
Went out of town for about 3 days,
Yes.
from November 16th to November 19th, is that correct?
Yes.
And during that time period, that's when Justice got a bruise on her head while she was with Janarius, is that correct?
I don't recall.
All right. You don't recall texting with Janarius about all that?
Not for November 17th, what you're talking about.
Talking about specifically November 17th of 2022.
No, I don't remember that.
You remember that around that time frame, we were talking about what you said was an injury caused by Frankie. It sounded like to the nose. She had a cold, right?
Yes.
And she was sniffling and blowing her nose, and her nose was running constantly. Is that correct?
Yes, on November 21st.
All right. And that was when she got sent home from daycare. Is that correct?
Yes, November 21st.
And you remember texting, well, first of all, you were Googling what to do about a nose that was so raw from running. Do you remember that?
Yes.
And you remember asking Frankie to go buy her some Aquaphor to put on her nose to try to heal up the redness. Do you remember that?
Yes.
So now, however, in retrospect, you're saying that all of that was caused by Frankie.
Yes, because he admitted to blowing her nose with a paper towel.
Okay. So when did he admit that?
Well, while we was on FaceTime.
FaceTime when?
On November 17th.
November 17th.
November 21st, I'm sorry.
Okay. So are you saying that that was some sort of abuse by Frankie?
It caused irritation to her skin on her face.
So on November, around that same time, you remember there being some blisters on Justice's hand?
Yes.
And when were the blisters on her hand?
The 22nd of November.
All right. And where was Justice, who was she with on the 22nd of November?
With Libra and I.
And so you saw these blisters on her hand, where? Which hand were they on?
I can't remember which hand it was, but I noticed them when she first was there.
Okay, so you put her to bed at night and there was nothing wrong with her hand.
Correct.
And when she woke up in the morning, you went to get her out of bed?
She just woke up crying.
Okay, and did you go get her out of bed?
We worked with her.
Okay, and brought her to you?
Yes.
And that's when you saw blisters on her hand?
Yes.
And you didn't know what those blisters were from?
No.
But you took something and popped them, is that correct?
Yes.
How did you pop them?
I just drained it.
How?
I forgot what object it was, but I didn't pop it.
Well, did you put a needle in it? Did you, how
I
did
don't
you?
remember what I used to pop it, but I popped it.
Okay, and did a doctor tell you that that's what you should do?
No one told me to pop it, I just popped it.
All right, and then what happened to it? Did it clear up or did it get more infected?
The liquid drained it out and then I put it in over it.
And when you pulled the Band-Aid off, her skin would peel off, is that correct?
Yes, it did once.
Yeah, and that's what you had indicated to the police and to CPS, that when you pulled the Band-Aids off the skin would peel off, is that correct?
Yes.
As to the heater that was in that bedroom, you were asked about that heater by the Detroit Police Department and by CPS, is that correct?
Yes.
And when you were asked about it at that time, you remember telling them that the heater didn't ever really get that hot?
Well, it wasn't that hot to me, but I know it's too hot for the lady.
Okay, do you remember telling the police that the heater didn't really get that hot? Yes or no?
I just said yes.
But today, you told the judge that that heater got pretty hot, correct?
Yes.
Would you give Justice baths at Frankie's house?
Yes.
And would you, in the bathtub, or would you give her shower?
Well, shower, I would wash her up in the sink and in the shower.
I'm sorry?
I would either wash her up, standing up and like while I sleep, or wash her up in the shower. We both take a shower today.
Okay. And so you didn't give her a bath in the bathtub?
Not there, but at my grandmother's house.
Okay, why not there?
Because this tub didn't work.
Well, and at your grandmother's house, how hot does that water get?
It's not very hot.
Not very hot. When you, oh, straight. The photo. The blisters on the hand, what date did that happen? You said the 22nd?
November 22nd.
And then you didn't see her from November 22nd until November 23rd until November 27th, is that right?
Correct, but I also took a video and a photo on November 28th. And I
Okay.
also showed her.
Okay, so the answer is you did not see her between November 23rd and November 27th.
November 23rd at 6 p.m. Yes.
Okay, until November 27th, is that
Yes.
correct? And did you have any conversation during that time period with Janarius about the injuries to her hand?
Yes. He was asking
And
me.
no, did you have any conversations with Janarius about the injuries to her hand? Yes or no? You can't tell us what someone else said.
Yes.
Thank you. You also had noticed, or he had noticed, and you had a discussion with him about blisters on her feet and in her mouth, because she had had hand, foot, mouth disease. Is that correct?
Yes.
And the blisters that we're talking about are blisters that you were noticing around this same time period. Is that correct?
Yes.
Yes? May I approach the witness, Judge? I'm showing you what the prosecutor showed you earlier, 30 and 31. Those are photos of Justice, right?
Yes,
Okay. What day were those taken?
I'm not sure where they were taken, but these are not my photos.
So you have absolutely no idea what day those photos were taken?
These are not my photos, so I don't know what day they were taken.
Do you know whose photos they are?
Her average.
The prosecutor was asking you about the night where, I think it was November 13th, when you spent the night at Mr. Matoyer's house with Justice. You said you had gone to work for a couple of hours, is that correct?
Yes.
And said that, well, what time was that at you went to work?
I don't remember the exact time that I worked that day.
I'm sorry?
I don't remember the exact time I worked that day. I worked different shifts.
Okay. And you said that Justice woke up in the middle of the night, and how did you hear her crying?
Yes.
Okay. So when you heard her crying, who went into the room that time?
I picked her up and went to the room and picked her up.
Okay, and you saw something on her, you said a scratch, I thought you said.
There was a scratch on her forehead and cut on her lip.
Okay. Now, when you testified about this, you have testified about this before, is that right?
Yes.
Okay. Okay, so you went to the prosecutor's office, I think, was it? You went to police headquarters and Ms. Ripley was there and there was a court reporter taking down what you said?
Yes.
Okay. And you told them that when Justice woke up, you said that she woke up with a knot. In the middle of the night, she got a knot on her head.
Yes.
Okay, so today you're saying she had a cut in her lip and a cut on her forehead.
That was where the knot was.
Where was the knot?
On her head.
Okay, so was it a knot, like a little bump, or was it a cut?
It was a knot and a cut.
Okay, well, how, you would agree with me that when you under oath testified about this the first time, you said that she got a knot on her head. That's all you told them at that point, is that correct?
I don't recall.
Well, would you like to see it? What does it say, ma'am?
It said that it was a knot on her head.
Doesn't say anything about a cut on her lip.
No.
Doesn't say anything about a cut on her forehead.
No.
And you're trying to say that this knot on her head is somehow the fault of Mr. Matoyer. Is that right?
Yes.
Okay. And why is that?
Because it happened in the room. So I don't know if she actually did her on the books on her, if he actually did something to it.
But you just are willing to make that assumption
I'm
that,
not making
wait,
that
I'm not done with the question, ma'am. You're just willing to make that assumption and blame it on him because who else's fault would it be? Is that accurate?
Are you asking me a question?
Yeah, I'm asking
So
you
what's
that
the
question. The question is, you're willing to make an assumption that it has to be Leroy Matoyer abusing your child.
No, I'm not making an assumption.
Well, you don't have any evidence that it was.
I actually do have a photo of her on that day.
Okay, and you have a photo of Mr. Matoyer slamming her head into the bar?
I have a photo before that day and after that day.
You were there that night with Mr. Matoyer when she was sleeping.
And also-
I'm not done, ma'am. You were there that night with Mr. Matoyer when she was sleeping in that room, is that correct?
Yes.
When the prosecutor asked you back when you made your statement at the police station, you said in the middle of the night, she got a knot on her head. He said she hit her head on the futon in the room. Question, did that seem off to you? Answer, how the bar was, it didn't seem off. What does that mean?
How the bar was positioned and how she was sleeping.
It didn't seem off, meaning it seemed like that's how it could have happened?
It seemed possible.
Now, you told us that the other thing that you wanna claim that Mr. Matoyer did to injure your child is her hair was missing, correct?
Yes.
Now, you testified that, today you said that when you were, I think, bathing her, hair started coming out of her head?
While I was washing her hair, yes.
Okay, so Mr. Matoyer wasn't in the room at that point, was he?
No.
He wasn't in there pulling her hair out of her head, was he?
No.
Did you take her to a doctor to see if there was some physiological reason for the hair coming out of her head?
No.
In fact, you hadn't taken her to a doctor, you'd missed her 18-month checkup and shots, is that correct?
I don't recall.
Well, that's what you told the police and the CPS, you missed your appointments.
I don't recall.
So today, your testimony is that you noticed that the hair was coming out when you were bathing, correct?
Yes.
In your notes, I think that you, and that's the first time you noticed anything about her hair?
Yes.
One moment. The prosecutor was asking you some questions about your relationship with Mr. Matoyer. Is that right? Today you told us that you would spend the night over there twice a week. Is that correct?
Once or twice a week.
Okay, so it varied?
Yes.
And you said that you told Mr. Matoyer not to discipline her. Is that correct?
Yes.
And you've been very clear that when you said discipline, you meant talking to her or directing her or telling her what to do, not anything physical. Is that correct?
Correct.
And you had never seen Mr. Matoyer physically hit her or assault her in any way. Is that correct?
Correct.
Now, in terms of your relationship that the prosecutor was asking you all kinds of questions about, you said that he had never been physically abusive to you. Is that correct?
Correct.
However, you said that he had left marks on you while you were having sex. Is that correct?
Correct.
Because one of the things that you and Mr. Matoyer liked to do was to tie each other up during sex. Is that correct?
No.
That's not true?
No.
All right. I didn't ask these questions to begin with. She did. Last question. You know that your phone was dumped and all your text messages have been made available for us to review.
Yes, I'm aware.
All right. And your answer to that last question is still no.
He never signed me up and I don't understand what that is.
All right. Your relationship, your sexual relationship with Mr. Matoyer, in spite of how you want to paint it, it was a consensual relationship. Is that correct?
Yes.
I don't have any other questions. I'm sorry, I do. The prosecutor asked you when she first began questioning you was when you first saw Mr. Matoyer at the hospital at Sinai Graves, if he had any injuries, if he was limping, and anything like that. Do you remember those questions?
Yes.
Now, the police asked you those same kinds of questions. Do you remember that?
Yes.
And you remember telling the police, I didn't pay attention, I didn't ask, I don't care, that wasn't the first thing on my mind. Do you remember telling the police answers like that?
I don't remember those exact words.
Okay, do you remember, maybe my words aren't exact, I could go back and find it, but do you remember telling the police that you didn't pay any attention to how Mr. Matoyer looked? It's in her two. You want to do the video transcripts? One moment, please. But we'll just leave it at this. What did you tell the police when they asked you if Mr. Matoyer had any injuries?
I told him that it was no noticeable injuries because he was facing back and forth. He wasn't planning on any injuries.
Okay, that's what you told the police?
That's what I believe. I told the police.
Okay.
And I'll be working with.
Thank you. Nothing further.
Can you read it?
Ms. Edmond, it wasn't your idea to lie about the length of time you and Mr. McClure had been dating, was it?
No.
And just for clarity purposes, who's Frankie? When we were talking about November 22nd, you noticed the blisters on Justice's hands. You said you noticed them when she first woke up, that she woke up crying.
Yes.
And that Mr. McCoyer went and picked her up.
Yes.
Were you in your bedroom at the time?
I don't remember where I was at the time.
But Mr. McCoyer went up to Justice's bedroom.
Objection. Now she's leading.
How did Mr. McCoyer go to Justice?
He went after a cigarette, and then we ate, and that's when we noticed the blisters on her hand while she was eating.
How long was Mr. McCoyer upstairs getting Justice before coming back down?
I don't remember.
This is at 6. that how justice was handled with the drop draw at Claire's house on November 22nd?
No,
And the first time you saw justice was handled like that was when?
on November 22nd. Oh, like this on the 29th, sorry,
You was at the hospital?
at the hospital.
On November the 13th, when you noticed her hair was missing. November 22nd. You said you noticed Patrick Justice's hair was missing?
Yes.
Who had Justice, right before you had given her a bath and noticed that?
She was sleeping before that, but when she woke up, Leroy was in the bathroom as well, noticing the hair was going out.
And when she was sleeping, was that in Mr. Matoyer's house?
Yes.
And was that, had you seen Justice before she went to bed that night?
No.
When did you get to Mr. Matoyer's house?
I got to Mr. Matoyer's house, around 12:15-ish a.m.
And, fair to say Justice would have already been asleep?
She was already asleep.
And before that time, Mr. Matoyer, had, been watching Justice?
Yes.
In your relationship with Mr. Matoyer, did he ever say anything about you having a child?
Yes. This happened the first time I blocked him. He was saying how he was going through standards to date me because he doesn't date women with children.
Nothing further.
And except that Mr. Matoyer wanted to babysit your child. In fact, he took her to the park and sent you pictures of them laughing and playing on the swings. Is that right?
Yes.
I don't have this.
Okay, so. The times that you left justice with the defendant, those times that you left, were you always going to work?
Yes.
Did the defendant work?
No, he didn't work.
He didn't have a job?
No.
So you've known him for August to November. And you and Justice would spend the night at his house, and then at times when you went to work, you would leave Justice with him.
Yes.
Right? On each and every one of those times that you left Justice with him, there was something, some kind of incident with Justice. Would that be fair to say?
Yes.
But you left Justice with other people, and there would be incident too. Right? Incident with the eye and left your mother. Is that right?
Yes.
Would you consider Justice being accident prone?
She was a very curious child, I would say, so.
Did she fall a lot?
Not all the time. Just when she was being curious about something.
Did she get injured a lot?
No.
Was Justice fairly fair skinned like yourself?
Yes.
I haven't had the privilege of seeing Justice. And the people haven't shown me any of the exhibits yet. Call me nosy, but I think I would like to see them. Thank you. Thank you. So when you're at the hospital, and you said the defendant made some type of threat to you about following his lead. The only thing that he indicated was that you were to tell the police that you had been dating longer than you actually were.
Yes, and how long can you been watching?
How long he's been watching. He said if you didn't tell the police that, he would kill you.
Yes.
So you had been leaving your daughter with the defendant for a short period of time. I count 3 days, 13th, 21st, and 22nd. Is that right? And then the 29th.
Yes.
Okay. Any questions based on the questions?
Okay.
So,
No, Judge.
thank you. Mr. Sorry. Next. Any other witnesses for the people?
No, Judge.
Any witnesses for the defendant?
Not today, Judge.
People?
Your Honor, we will look at the bind over, arson, plate warrant. To the questions that answer how to any argument or
So,
Judge, we object to the bind over. I mean, this to me looks like the classic case where there is sadly a child dies accidentally and they backtrack to make anything else that ever occurred to some kind of child abuse, including a runny nose, that hair falling out that she notices when she's washing the hair. I mean, that's not how hair falls out, Judge, if it's being pulled out. And again, talking about the complainant or the mother who came in here to testify as she did, and I'm sure that she feels a tremendous amount of responsibility. But what we have is her telling us that Mr. Matoyer called her, said there was a fall, he's upset, and he calls EMS right away. They all converge on the hospital, her and Mr. Matoyer. And she doesn't call any other family members. Instead, she, I think in retrospect, makes up this story that it's gonna look better for her if she tells the police that she knows this man and trusted this man, and shouldn't have any responsibility for anything that occurred. And that's why she stretches out the length of the relationship. I mean, it's just such a nonsensical story, the way that this witness presented it, to make Mr. Matoyer into this horrible, threatening man. It's not like he said to her, you know, you better say, you know, you were there with me. It's not like he said to her, you know, anything that would, you know, take blame away from him. Instead, he says, if you don't say that if you don't take my lead, I mean, the lead in what? I mean, what happened? What was she supposed to do? So again, we heard from two medical professionals who, you know, I don't know, Dr. Sung did a halfway job, near as I can tell, on the autopsy in this case.
Why do you say that?
Well, because there's a lot of testing that Dr. Sung could have done that Dr. Sung didn't do. that we talked about at the time of the preliminary examination to testify. Dr. Norak wanted to testify and wanted the court to believe that a fall from the second step is the same as a fall from the top step. We heard from this witness that the stairs were slippery. You've seen a picture of the stairs yourself, a steep set of wooden stairs. There's no banister, there's no railing or anything to hold on to, making the story as presented by Mr. Matoyer immediately upon the incident occurring likely, highly likely. And there's nothing that has been testified to today or the last time that we were here that would indicate that Mr. Matoyer intentionally did anything to cause the death or the injuries to this child. None of the injuries, frankly. There hasn't been anything to establish that any single injury that this child suffered was as a result of any intentional action on the part of Mr. Matoyer. So for those reasons, we think that the people have failed to sustain their burden, and we ask the court to dismiss the charges.
Yes, Judge. Defendant is charged with first-degree felony murder and child abuse in the first degree. Looking at all of the elements of the crime, Your Honor, based on the testimony that we have, we believe that we have proven these charges to the probable cause standard. We'll look at the medical records first. We have medical records of Exhibit 1. We have Dr. Norak testimony. He testified to multiple pattern injuries, bruises in the shape of some object. The left side of the face pattern consisted with the handprint as he showed us, and it's reflected in people's Exhibits 15 and 17. On her legs, pattern injury with a flexible object that was wrapped around her leg, showing people's Exhibits 20 and 21. The injuries were caused by non-accidental mechanisms. He testified it was very, very, very uncommon for a fall to cause. You can't cause all of the injuries. We're talking about 1 in a million, maybe. When asked if a fall down the stairs would cause for accidental injuries, if there were any, no, he testified. He says if a child is falling, I would expect the bruises to be more non-specific. They wouldn't be in a shape or pattern like the ones that we see. And they certainly wouldn't have the shape of a hand pattern, like this kind of shape on the hand at the side of her head, the one that she's referring to in the exhibits. When asked if the fall could have caused her internal injuries, no. Even when injuries have been documented in those cases, if a child has a skull fracture, they might have had a localized brain bleed, but those children still don't die. Death from a stairway fall is not something that they documented frequently. We talked about the timing of the injuries. Because of how severely she presented, these injuries had been documented almost instantaneously. Almost instantaneously, they quantified to minutes from when the injuries happened. A fall down the stairs would not cause all of her injuries. When asked, could a stair fall cause the fatal head injury? Typically, no. When asked, have children died as a result of accidental falls down the stairs? No. Based on his experience and medical literature, there's no cases documented. He testified, and I know that Ms. Silver seems to object, however, we are not the experts here. He's qualified as an expert in general pediatrics and child abuse pediatrics. He's the one who went to school. He's saying that if children.
He may be an expert, but I do have some conversations. I think, I like to think I do.
Yes, absolutely.
And it just does not sound right to me that
Judge,
a fall from 15 steps would have the same injuries as a fall from 2 steps. That makes no sense to me whatsoever.
Judge, it does to me, because it's the initial, yes, because it's the initial impact where you would receive the most injuries, that initial drop. The rest of the tumbling or falling, he said it's just those incremental 6 to 8 inch falls. If we were to fall 6 to 8 inches, you wouldn't expect to be injured or bruised or things like that. And he's one who testified in his experience and on all of the medical literature, which I did forward to Ms. Silver. And I know that they probably have an expert dealing with that. We don't have an expert from her to testify here. We have my expert, doctor that I could understand, Dr. Norak, who testified that the literature is consistent with.
I don't know how you feel, but I would prefer to fall from 3 steps as opposed to 15.
Judge, I can't say I've ever fallen down the stairs like that, so I can't say. However, We have his testimony that the quantity of the stairs that they hit does not dictate the degree of the injury, because it's that initial drop that would cause the injury. You wouldn't expect more injuries from different heights of steps fall. When asked, are pattern bruises always intentionally inflicted in your opinion? With rare exception, yes. Then we have Dr. Sung testimony and medical examiner's report. Dr. Sung testifies that there's no other medical explanation. There's not a hypoxic ischemic brain injury. The bruises are not from IVs. None of her injuries could be from an adult falling on a child, as well as falling down the stairs. A single injury may be due to a fall down the flight of stairs. However, there are multiple injuries on multiple regions of her head, and collectively, they would not have been falling down the stairs. I would argue that that's consistent with Dr. Norad's testimony regarding the injuries from the first impact of the stairs, the first fall, the first impact. He further testifies that the injury to the brain and the constellation of injuries to the head could not have been from an isolated stair fall. He does testify that without the rest of the injuries, the stair fall would have to be taken more into consideration. However, that is not the case that we have here. We have all of these injuries, which need to be taken into account altogether, which is exactly what Dr. Sung did, and which is exactly what Dr. Norad did. Dr. Sung also testified that these injuries occurred on or around the same time due to the appearance of the bruises and the color.
I think that's the most compelling part of the testimony.
I don't disagree with you. It's very compelling. I think it's all compelling, but
You said the most compelling.
yeah. And then we move to Ms. Edmonds' testimony, which we just heard today, and it's very fresh in our minds. Mr. Matoyer watched Justice just a handful of times, and she noticed things that were wrong with Justice afterwards. We know that he went out of his way to ask to watch Justice. We know that she's had concerns about disciplining her, maybe not physically, that she would know of, but he was a strict person in their lives. We know that Justice was physically healthy when she was dropped off at Mr. Matoyer's house in the morning of November 29th, 2022. Judge, we also have it laid out in my demonstrative exhibit 40, thing that shows a pattern. I think it shows escalation. I think that asking to watch her. We also know that he at one point told her that he lowered the standards to date a person the child. That doesn't mean that maybe there was times he took her to the park and played with her. That doesn't mean that there weren't. But I still think that overwhelmingly the evidence shows the opposite. And Your Honor, there's a lot of circumstantial evidence, which we all know that it's just as good as direct evidence. Just because no one saw this happen doesn't mean that didn't happen. Of course, no one saw it. No one generally abuses someone for a child in front of other people. And just because no one saw it doesn't mean that they get to get away with causing harm to this child. Your Honor, we have to prove that the defendant intended to commit the crime of the act of abuse, that he intended to cause serious physical harm or knew that serious physical harm would be caused by his or her. The issue of malice must always be submitted to the jury. When we look at his intent, defendant's intent can be proved by what he did, what he said, how he did it, by any other facts and circumstances in evidence. Malice is required for felony murder. It can be inferred from the type of weapon used and the manner in which the crime was committed. And we know that the defendant's state of mind can be inferred in the same way. We can infer from this type of weapon, type of wounds that were inflicted, the acts and words of the defendant, and any other circumstances surrounding the event. Your Honor, I think based on all of the evidence presented, you have it all in front of you, based on the law, people have proved the case to a probable cause standard. We ask that you find over on charges in the complaint warrants. Thank you.
Let me start by saying I don't put very much stock into the allegations, if there are allegations at all, that she being, Baby Justice was being abused by the defendant in these other occasions. The only occasion I'm really concerned about is the one that allegedly took place on November 29th, 2022. All this other stuff about the bubbling on her hands, the falling out of the hair, all that type of thing. I don't know. I can't make heads or tails of that. Anything I don't have to. But for all intended purposes, I have before me Lady Justice who has some very serious injuries, bruises all about her face and back and stomach. It appears to the doctors that testified in this matter that she had been abused, at least two of them, that she was abused. And I believe that that's the most compelling part of the people's case, are the doctors that reviewed her medical records and reviewed her body and saw the injuries to her body and said that those injuries are inconsistent with a fall down the stairs, or even a grown man falling on top of her after a fall down the stairs. Now, perhaps Ms. Silver can get someone to believe that that's what happened and that's what caused all of these injuries. But a rational trier of fact could find, as the doctors have testified to, that it's implausible, that it's not possible that these injuries were caused by a fall down the stairs and by someone falling on top of the child after falling down the stairs. That being the case, Baby Justice did not deserve this. Pictures I see, she was a beautiful little girl who clung to her mother. I just wish, and I don't even blame anybody. Blame anybody. I wish that we would take more care of who we leave with who we leave our children with. Especially someone you don't know very well yourself. What are we doing with it? What is the attraction to this guy who has no job? Why you go to work, you leave your child with him? What are we doing? Justice Starks deserve better than that. Hindsight is 20/20 on this. But as it relates to this case, there is circumstantial proof that the defendant is the person who caused the injuries to Justice Starks. Court finding these charges were committed in the city of Detroit. The court finding probable cause to believe this defendant committed will bind the defendant over to Wayne County Third Circuit Court Criminal Division for proceedings. His arraignment on the information, date and time will be June 8th, 2023 at 9:00 a.m.
I'd like to address that if I could, please.
Okay.
I know that we did have a report done in this matter. I don't know what the report says. Mr. Matoyer is 37 years old. He has no prior criminal history at all. He is a lifelong resident of the city of Detroit, owns a home on Lancashire. He has substantial family ties to the community. The reason that he doesn't work is he is a disabled vet and he receives a disabled veteran's pension because he served our country and as a result of it became disabled. He served our country overseas, so that's why Mr. Matoyer is not working. As I indicated, he's got a mother, father, and other family members who are local. His mother actually is a nurse. I am asking the court to give Mr. Matoyer a bond in the amount of $100,000, 10%. And he would surrender any passport if the court wishes. And continue the no contact provisions.
Did we get a DSU?
We should have, we asked for it like 3 times. I know the family was contacted and interviewed. Mr. Matoyer also indicates that he was interviewed as well in April.
So I asked again.
Well, Judge, I wanted to see the DSU. I thought when we were here last time, you mentioned something about saying no action. But to do that, I probably had one. I kind of feel object to any kind of reduction in bond. Your Honor, you heard the facts in this case. Exactly the date the community introduced the child. Just don't know. We also think that there's a flight risk. That's great, fantastic, but there's the documented times that reached out to. No idea where he was. Yes, sir.
Okay, you know what, that's not true, and I'm gonna stop her right there because that is not true. Mr. Matoyer contacted me early on in the case. I immediately contacted the Detroit Police Department and I advised the Detroit Police Department that I was representing Mr. Matoyer, probably within a couple of days of the incident occurring. When the police notified me that they had a warrant for Mr. Matoyer, we turned Mr. Matoyer in. So to say that they didn't know where he was is completely dishonest, because I spoke to Detective Biffle and I spoke to Alexander as well.
Well, I wasn't aware of that, so.
Looks like you have a report. Recommend no action.
We have to got that.
Okay, so the defendant was honorably discharged from looks like the Navy back in 2012. Although when he went to the 11th grade, he got his GED, and he does have some college education. The defendant, by his own reporting, indicates that he has some mental health issues and suffers from PTSD.
That's correct. He treats at the VA hospital.
Given the seriousness of these allegations, as well as though he's been in Michigan since the age of 5, the original times that he was born in Louisiana, given his outside ties to the state of Michigan, and it sounds like he has a passport as well as some mental health issues. This court is going to err on the side of caution. I am going to deny the request to reduce the fine, continue the violence.
I do want to just comment on that, Judge. The family has lived in the state of Michigan since the defendant was a small child. He doesn't
Since
have,
he was 5 already.
that's correct, doesn't have ties anywhere else. Certainly surrendering a passport, which is what we frequently do in federal court, would ensure that the defendant is not able to leave the country. As far as the PTSD and the depression that he suffers from, he's not getting any treatment for that inside jail. He has suffered from that for a long time, and that is why he treats at the VA. So he's not a flight risk, and there is certainly a combination of conditions that could be set by this court that would ensure the defendant returning to court, as well as the safety of the community if that's a concern, such as a tether, house arrest, surrender of the passport.
So I appreciate my position. I just found this defendant over felony murder child abuse first degree. He reportedly has a mental health condition that he suffers from PTSD. The pretrial services recommend that I take no action on bond. Prosecution is asking me to take no action on bond. And one of the allegations here is not only that he allegedly abused a child to the point where that child was killed, but that the mother says that she was told that if you don't follow along with my story, I'm going to kill you. All that being said, you're asking me to reduce the bond.
That's correct, Judge, I am.
No.
Thank you.
Continue. Thank you.
Yes.
I said, okay. Ms. Silver, his AOI date is June 1st, 2023 at 9 o'clock.
Not the 8th?
Not the 8th. He's in custody. June 1st. Thank you, you too. Thank you.
Absolutely.
Tuesday. Yana, you have a good afternoon.
Thank you, too.
All right.
Appreciate it.
No problem. All right.
Thank you, you too. Always a pleasure seeing you, Your Honor.
Okay, thank you. Thank you so much. Have a great day.
Also, thank you.